unknown, down the rabbit hole, where it stops no one knows. We're going head into the unknown. Na, 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 na.
Might help if I actually add myself to the stage. Otherwise, I don't know what we're going to be doing all day. Hi, everybody. Happy Monday. Welcome back to Criminality. Or if this is your first time here, welcome to Criminality. Today, we're going to be talking about the case of South Carolina versus Zachary Hughes in the case of Christina Parcell. We have no court today, so we are going to be looking at some of the pretrial motions and checking out John Melo's federal complaint. I tried to just pull up some of the major documents that we kind of had questions on. This is definitely not all the documents, so I don't want anybody to be confused because we're not necessarily going in order of how everything was filed. Just trying to get some backstory on some of the questions that I and Chad have had about the case. Because if you guys know, we went in blind, or we tried to, mostly blind, kind of like with sunglasses on almost, because we knew a little bit, but not really all the details. So let me say hi to you guys, and then we'll get started. Sorry, I was running a little bit late because I was hanging out on case by case for a little bit, and then I had to get myself ready for this live. So, what's up, Journey? I fell asleep before the end of the live last night and watched all the thumbnail hilarity on replay. Oh, Journey, I'm so sorry. It's always fun because you can tell who actually watches the entire live. When we go off the rails, when people make comments about it, I'm like, at least you watched the whole thing. Hi, Ems. What's up, Law Junkie? Hi, Dina. Hi, CH. We're starting to debate thumb toes if you didn't show. It wouldn't surprise me. If Sleuthy was here, there'd definitely be a thumb toe debate. Hi, Catastrophe. What's up, Thomas? Hi, Mav. Hi, Legal Lacey. Hi, Boo. You checked probably 10 times. So I'll tell you guys, I think that being live all the time is like killing my throat, because my throat has been killing me. Like last night, today, I don't know if I'm just talking too much. Maybe I need to shut my mouth. But so I like rested most of the day away. Hi, Brittany. Hey, Bree. You were looking for toes. I stayed up way too late down the toe rabbit hole. I will just tell you. It was not appropriate. I was like, what am I doing with my life? I've got to find another hobby. Hi, Jade. Hi, Tammy. Okay, so I did do some research on this, the backstory of this case, but I did find some interesting Reddit posts, so I thought I'd share those with you guys. Let me bring this over here. So we talked about how Zach Hughes was in contact with Isabella, and Isabella is, okay, so I guess we should probably just kind of run through the characters so that everybody's on the same page. So Christina Parcell is the victim. The defendant is Zachary Hughes. Zachary Hughes was friends with Christina Parcell's ex, John Melo, who's the father of her daughter, and they were in a very contentious custody battle. Christina Parcell had a boyfriend named Bradley Post, a fiance named Bradley Post. When the investigation into her murder was going on, they confiscated Bradley Post's phone and found a bunch of CSAM. If anybody doesn't know that, it's bad pictures of underage people. Also some with animals. Now, they didn't just find all that on his phone. They found hard drives and thumb drives at Christina Parcel's house. So this is kind of what we've had a lot of questions on, is the backstory of when did Melo know? When did Melo know about the CSAM? Because I don't think it ever came out until after the murder. And when was he very first accusing Christina of some form of SA towards their daughter in this contentious custody battle? What we know from trial is that that Zachary Hughes and John Melo worked together to use old nude photos of Christina to create online profiles for escorts. So that's kind of, I think, the general gist of where we're at. Now, I did want to bring something else up that I did not actually bring up. So give me 1 second and I'll pull that up too. But I did find, so Isabella, being John Melo's daughter from a prior marriage, I did find her on Reddit. Well, it's somebody that claims to be her. It seems to be her. Commenting on the case. So I thought that was kind of interesting. Nope, I don't want this. Wrong network. Sorry, hold on. I think it's this one. So I thought we could watch this also. This is that the pretrial where they're determining whether they're going to let certain things into court. So I also have that up for us to watch. Okay, let me come back over here. I was reading that he was upset about sleeping arrangements and other things going on in the house that he didn't like or approve of. I think that goes to the rumor of, well, I don't know how much we want to call it a rumor, but the speculation, or whatever you want to refer to it as, that their daughter was sleeping in bed with Christina, and then Bradley Post was coming over and also sleeping in the same bed. It's tough. It's tough because I don't think that anybody's minor child should be sleeping in bed with some other dude. But then I have friends of mine who, like, their step parent was like they ended up being the best parent they had out of all their parents. And so it's like, I don't want to just like summarize everybody into it, but I definitely think it's something that is kind of like something to look into. Like, wait a minute, why would my kid be sleeping in bed with somebody else at all, ever? I don't know. People are going to have their own opinions on that for sure. So, somebody asked what the debate was about the toe. Oh boo, oh boo! You don't even get into the toes. Yeah, it's a big weird no. So the kid, so their daughter was 9 at the time of the crime. Christina had been with Bradley Post on and off for about 6 years, I believe it was. So she would have been like 3. Hi, Sleuthie. She would have been about 3. And they were not married. They didn't live together. No, boo, I have not seen that. I haven't seen that. So I mean, like I had a big issue with it when we talked about like Maddie Soto when it comes to Stefan Stern sleeping in bed with her. So I can see the issue on 100%. Like, I think it's weird, and I would not personally do it, but all right, let me show you guys the screen so we can start talking. This live is gonna go about as long as until Bob starts, because Bob is gonna be going live talking Delphi with all the new documents that he hasn't had a chance to go over. So this live is gonna run up until right up a little bit before Bob starts. So if we end up cutting off in the middle of something, I apologize, but I want to watch Bob's live. So just FYI. I did hear that Andy was going to be on. I didn't see any confirmation of that, but I did hear that. Yeah, Bob's going live finally on the Delphi stuff. So I just want to, just an FYI, we're gonna quit right about that time. Okay, can you guys even see this? Let me see if I can make it bigger. Okay, so her name on Reddit is the Melo Submarine. Bob did confirm it. Okay, thank you. What, somebody can drop the link for Bob. I'll probably end up rerouting everybody to Bob anyway. So if you want to, if you're here at the end, I'll probably just I'll portal everybody over. But yeah, I don't want to miss that. So I'll be there for that. This is so this is just a Reddit thread talking about the case. And where the heck did it go? Oh, here it is. I was like, wait a minute, where did it go? So here, this is her, the Melo Submarine. So there's another, supposedly some other guy that was doing CSAM that was caught in California that people have confused with being the same John Poe. Sleuthy, I sent you that link for that Pacer because I don't have a Pacer account. But she claims that it's not the same person. So I don't know if that's even important to what we want to talk about. But because people were saying that even the X had, you know, CSAM stuff. Let me see. There was one that had the interesting post, and I should have already had that up, but I forgot, so I didn't do it. I started talking Delphi, and you guys know how that goes. So she says, I'm happy to answer any questions that I'm legally allowed to. Like certain people who were supposed to be fighting for my siblings' best interests straight up lied about speaking to the DAs and the State Department, and we have letters from those people stating that they didn't actually speak with them. Kind of makes you wonder why the other Parcell also didn't get custody, which would be Tina Parcell. Melo Submarine is Isabella, which is John Melo's daughter from a previous marriage. She ended up with temporary custody of their daughter, of Christina's daughter, after Christina's murder. So this person says, yeah, she was pretty evasive and she had an agreement with John. Sure, she did. Your dad got her because that's where she belongs. They allowed all the accusations John made against Christina except the SA. Allow them all or allow none. He accused her of using drugs. They said there was no evidence of that. Okay, so why not let the facts and the truth come out about the other? That's unfair in my opinion. Hi, Butterfly Kisses. So then Isabella says, that's annoying. They straight up said there was like a bag of cocaine somewhere on a table where my little sibling had literally just left for school from like hours before. I don't care if you're not actively using it. You had it in the house. Is that not bad enough? That, just fair warning, she's very, very supportive of her dad. Very, very supportive of her dad. And then somebody responds and says, hey, yesterday the Guardian said she was going to recommend the child be placed with Christina, knowing what she knew at that time. She said, I'm watching Vinnie Politan on Court TV, and a local reporter said what the jury didn't hear was that if she knew then what she knows now, she would not recommend placement with the mom. She would get the child out of that house as fast as she could. The jury is left believing she would be recommended, but we all know that's not the case today. That shows favoritism toward the prosecution. If it's not allowed to be brought up, then that should have never been said either, because today, at the time of this trial, it's not true. I didn't know if you were all aware of this. And then she says, I have another question. I don't know if it's appropriate. You may not want to answer it, but I respect that. Did your dad know about the sexual abuse or thought it was other forms of abuse? And then Isabella says, yeah, it was reported to GCSO several years before, and they ignored it because they thought he was making things up to help his custody case. This is just a few days ago, Legal AC. We have emails and documents where he was literally told to stop contacting the cops about it, despite some of the really creepy stuff my sibling was saying. There's more to it that I don't know if I can discuss, but yeah, he tried for a long time to get people to listen. And then she adds, I also think it should be allowed to be discussed in court, even if they can't discuss what they found at the crime scene, since this was documented in like 2017, 2018. I can't remember exactly which year, but I can look it up. The Guardian knew this had been reported. Everyone knew this had been reported. It just wasn't proven yet. According to Isabella, it's coming from Aida. Aida, is that how you say her name? So then somebody else asked, what's the importance of the doors? Tina was adamant they never used the back door. She said it stayed locked all the time. Then the next day I saw posts using the back door on that day. Isabella responds and says, from what I was told, there was a huge hole in the fence in the backyard, and the neighbor's security camera that might catch the back door was out. They want to claim someone went in and out of the front door, and they want to claim that person was Zach. Meanwhile, someone could have waltzed in through the back fence and door, and nobody would be the wiser. So that's another thing. She does bring that up in another post also. Hold on. So if she's been on the subreddits for a while, just FYI. I think I've said just FYI a few times now, but she's been on there for a while. These aren't necessarily new. This one right here that I'm going to talk to you about is from 2 years ago. She does imply that the person, she doesn't say it straight out, but she does imply the person that she believes is responsible for her murder is Brad Post. So this post is from the comment's from 3 years ago, but her comment is from 2 years ago. So the person says, well, now with today's news break, Christina is formally implicated in the manufacturing of child pornography. She certainly wasn't innocent. I pray for her daughter's peace and healing, and for the children who were ever in these monsters' care to be a very short list. If it wasn't for Christina's murder and the subsequent investigation of the crime scene, none of us would know what was really going on at her house. Seems people were fooled. Such a horrifying and sad story to have unfold right here in our own community. Isabella responds and says, Christina's daughter is my little sister, and she is doing well. She is brilliant and sweet and lives life to the fullest. And she and my dad are joined at the hip, and she just gets to be a normal kid now. We tried reporting for years what Christina and Brad were doing, and nobody ever believed us. But now the Supreme Court of Italy is on our side, and she is safe and sound. I should back this up just a second, because somebody above says how they don't like John Melo. Here it is. So right above this one, it's, I'm afraid I know John Melo, and he is a true form psychopath. He tried to get a roommate of mine to, quote unquote, bother a child's mother because of custody issues around this time. Thankfully, he did not entertain the notion. Melo's Facebook profile used to be like a tribute page to his daughter in a not so healthy seeming kind of way. Like a lot of pics of him and her, and comments borderline real creepy. This profile no longer exists, I've come to find out. I've been a Greenville resident for almost 4 decades and just recently heard about this case and started researching it. And I'll say this, from what I know about Mr. Melo, I can honestly see him finding some weak-minded crash dummy to pull this off, as he tried to solicit my roommate to, quote unquote, aggravate the baby mama. Little did I know that such a tangled web of shit this involved. You guys are going to the we. Back to when she said we tried to report it. Yeah, we. She said we tried to report it, including, she's trying to say she tried to report it too. So I thought this comment was pretty interesting, because this takes us back to that Alex Fields guy, who, the one that Sleuthy and I found when we were live that died in the accident, is apparently the right one. And there was, at the time, and this is all just what I'm learning through doing this back research, is that Alex Fields was somebody that John Melo had tried to solicit to go and harass Christina. And so Alex Fields came forward and said, yeah, I know this guy. And I don't know. So I don't know if this is if this person right here is the roommate of Alex Fields. I don't know any of that. But I just thought this comment was interesting because now we do know that Alex Fields was essentially solicited by John Melo to harass Christina also. Yeah, and her calls with the defendant before and after. Yeah, don't forget that. Isabella is 30, and I believe Zach is now 33. So they're very close in age. Okay, so let me go back down. So the person comes back again and comments under hers and says John Melo is a true psycho-sociopath. And then people are getting like all up in it, like, hey, well, what would you do if somebody was like harming your child and you couldn't get help? So this seems to be like the dividing factor in this situation is, did John Melo know that all of this was happening? And of course, so he does all of these things to save his daughter because nobody will help him. Or does he not really actually have any idea what's going on? And he just wants his daughter, so he creates all of this stuff about how Christina is such a terrible person. Hi, Leanna. Hey, Crafty Chris. I think the poor girl is like, the person I feel bad for is this kid. Like, I really just don't think that she should be around any of these people. I think that I'm not surprised that she was taken out of custody and put into foster care so they could determine who in the world would be the right place for her to go. How they decided John Melo was after everything he's done, I don't get it. It does sound like Melo is a master manipulator. Yeah, and Zach isn't, but I mean, Zach didn't roll on Melo. Like, that's weird to me. Why not? Matt's like, yeah, all of it. I think they're all awful. Apparently there's video. So here's the issue that I'm running into with this stuff is Brad Post's case is very under wraps, probably because of what the charges are. Now, obviously, they say I should say Zach Hughes' defense team is very much using the CSAM as part of their case, or wanting to, which doesn't make sense to me if they're saying that he didn't do it. They're trying to say like somebody else would have had motive. So almost to try to like elicit like third party, but then they're saying that nobody else knew about it. So I don't really understand that. It seems like that's what it sounded like, was that she's in Italy with John. I don't know if that's true, but that's what it sounded like from her post. So most of this information that we have about Christina is from Melo himself and Zach Hughes' attorneys. Does that make it not true? No. Does it make it true? No. So that's kind of where I'm still stuck at. There's obviously something to this, and so I'm not trying to downplay it whatsoever. I just don't put anything past this fucking Melo guy at all. There's another one. Let me see where it is. I think it might be in this thread that she comments again. Because she does bring up the fact that she brings up this backyard camera again, or the neighbor behind him's camera that doesn't work. She's like really, really wanting more info on this back camera. She also talks about, it's got to be in this thread. Just give me a second. I'll find it. But she also talks about like the DNA and how she doesn't believe the DNA. Maybe it's not this one. I thought it was that one. No, maybe it's this one. No, wrong one. It's the one that is like court cases. Why don't I see it on this one? It's like we follow cases. Cases we follow. Here it is. It's got to be this one. No, maybe I'm wrong. But she brings up that camera again, and she also brings up DNA. I don't remember what thread it was on now, though. Of course, because I didn't bother to like go through and actually save them. I think I went to the bottom of this one already. Yeah. Anyways, I'll try this one, and then I'm going to move on because we have a bunch of other stuff to cover still. See, Law Junkie, I agree with you. I do. I agree with you. I would do anything I could to protect my child from something along the lines of that. But I just don't. I don't know if this is out of protection for her or out of. I guess I can't determine in my own mind if it's out of protection for the daughter or if he's using the daughter as a pawn to get what he wants, because he also has that personality. So I just don't know. I don't know how I feel yet. All right, let me go through this one really quick, and then if it's not this one, then I'll move on. Because I thought there's one that she talks about the DNA that I thought was interesting, and now I can't find it. But we have too much other stuff to cover, so I don't want to spend too much time doing this. This was just an interesting little side info. I should have just pulled up her username, but it is what it is. Okay. There's another one that she talks about not believing the DNA. And like so if she says something like if the court's trying to say that Christina fought back like so hard and so much, then how would the DNA only end up under like the one little finger? Okay, so we're going to read through some of the lawsuits now. These are civil lawsuits that are filed against. Why does it look like that? Hold on. These are the civil lawsuits that are filed against Bradley Post and Christina Parcells' estate. There's information in here that is going to be hard to hear. I'll just say that. So if this is not something that you can handle or can stomach, then just know, like, it's okay. Like, you don't have to. Oh, really? Aaron said the Fitz News reported the defense lawyers said on the way out of court on Friday they were not sure they would even need to put on a defense. Well, I guess we could do. Let me pull up the actual video. We could do a poll on where we stand now that the state is rested. We can put up what you guys think. Let me pull up this video though. Pull up this video. That's just my echo. Let's put up a poll. I think they need to put up a defense. If you want my opinion, I'm going to say I think they absolutely need to. As of the state's resting their case, do you think that Zachary Hughes killed Christina? I think we're all in agreement that the harassment was proven. I think that we're kind of more at the point of the murder charge. And remember, the defense doesn't actually have to do anything, but in my opinion, I think they should. I think the DNA will be damning for him. If they don't try to put up somebody that would show like the cross-contamination, I don't think they drove that point home enough, in my opinion. Ariel, the defense tried to insinuate with the lab tech, that the girl who was doing the serology, that she also was cutting the tips off of the buccal swabs during the same time that she was processing all the items, including the fingernails, for DNA. So they're essentially accusing of a cross-contamination, and that's how his DNA ends up on the fingernails. I don't know if they drove that point home enough, because juries like DNA. They really just do. So I don't know. Okay. So if you told me right now I had to go vote, I'd vote that he's guilty. That's where I'm at. I vote that he's guilty. And I know that the defense doesn't have to prove that he's not guilty, so I would vote that he's guilty. They'd have to put something in the jury's mind of that there's all these other possibilities and how these other possibilities were. And they just didn't do that with the Cool Whip. Yes, I did get it. Thank you for sending that. I haven't had a chance to respond, but yes, thank you for sending that. I did get it. She was not the same one processing the go-go powder. No. that was the other lady who was, I think, using a little bit of that go-go powder. So they've already done all the DNA. State has rested. So the DNA is there. The DNA, his DNA was found on her fingernail. Okay, so this is the first lawsuit. I don't need to read all that. So this is the plaintiff complaining of the defendants named herein would respectfully show unto this court as follows. The plaintiff they're going to consider is John Doe. The plaintiff, Eden Rogers, acting on behalf of John Doe, is the mother of minor child Jane, or I should say Jane Doe. I don't know why I'm saying John Doe. It's Jane Doe because it's a little girl. And Jane Doe is the natural child of Eden Rogers. So this is the friend of the daughter. So both Eden Rogers and Jane Doe are citizens and residents of the state of South Carolina. The defendant, Bradley Post, is a resident and citizen of the state of South Carolina. The estate of Christina Parcell is being administered in the county of Greenville by Christina Parcell. No, not by Christina. Christina Parcell was a resident and citizen of the state at the time of her death. Her sister, Tina, which is Lutina, you name your kids Christina and Lutina. Lutina is the one who's actually in charge of her estate. So here, this is what they're claiming. The plaintiff incorporates herein by reference each and every allegation set forth here and above as if repeated verbatim. Jane Doe was a friend of Parcell's minor daughter. Jane Doe spent time with Parcell's minor daughter while under the supervision and in the care of Parcell. During the time that Jane Doe spent with Parcell and her minor daughter, Parcell and Post took pictures, videos of, and with Jane Doe. That's the big one right there, the with. Jane Doe in states of undress and in sexually provocative positions. The plaintiff is informed and believes that during the investigation of the murder of Parcell, a search of Post's cell phone revealed the contents of inappropriate and sexually explicit nude pictures of Jane Doe taken with and in the presence of Parcell. The plaintiff is informed and believed that Post was the fiance of Parcell. The plaintiff is informed and believes, in addition to the photos, videos of Jane Doe found on Post's phone, a search warrant for Post's residence resulted in the seizure of various computers, video cassettes, cameras, cell phones, thumb drives, recording devices, digital storage devices, and tablets. A review of these items revealed sexually explicit nude pictures and videos of the plaintiff, Jane Doe. So here's the thing that I got confused on, and maybe it's both, and that's why I'm confused. But one other document, and I think we'll probably read that one too. It states that all the thumb drives and the hard drives were found at Christina Parcell's house. This one states they're actually found at Post's house. So maybe they're found at both. I don't have any clarity on that. Like, that's kind of like they're claiming two different things. One said they were found at the crime scene, which would be her home. It was her right hand nail clippings. So this is, that kind of throws, so I mean, still, I don't know why he wouldn't have fucking got rid of it, knowing that his fiance was murdered, but whatever. I mean, that's stupid on his part. But, you know, he's just, if it's all at his house, see, if it was at her house, it would, I don't know why he would call the cops and not get rid of everything. That just didn't make sense to me. So I guess we have to go with, I don't know which one they're actually found at. At all times that said inappropriate pictures, videos were taken, Jane Doe was and continues to be a minor child. Unless he took everything with him. Maybe. Yeah, maybe he put it all in his car. They don't typically, I don't think they break it down by each finger. I think they swab all the fingernails together. They're all put in the same bag. All fingernail clippings from the right hand are together. All fingernail clippings from the left hand are together. So I don't think you can distinguish that. They're all put into one baggie from each hand. Just FYI. That's how they're collected when we're talking about DNA. So it wouldn't have been finger by finger. They clip them, put them on a paper towel, and then put that, or a sheet of paper or whatever it is they use, and they put all of that in one bag. And then they do the left hand, and then they clip them all, put them on one sheet of paper, and put all that in the other one, including the paper. So she was and continues to be a minor child. Thus, such photography and videoing of the child could not be consented to by the plaintiff, Jane Doe, and such was not consented to on behalf of Jane Doe by an adult having legal custody guardianship of her. In addition, the pictures revealed that Parcell was present in the images showing the plaintiff, Jane Doe, in a sexually provocative state of undress. Parcell was entrusted with the care and control of the plaintiff, Jane Doe, while in her care. So they are saying Christina is in the video / photos, that you can see Christina in them. While in the presence of the defendants, Jane Doe was photographed and videoed in various stages of undress, including the photographing and videotaping of the plaintiff's breasts, genitals, and pubic area. The defendant Post, with the consent and assistance of Parcell, imported these videos to his cell phone and computer and saved them in files on his computers and other storage devices, making the plaintiff, Jane Doe, the object of child pornography. What the fuck? What is wrong with these fucking people? The plaintiff is informed and believes that the defendants knowingly and intentionally forwarded to others from his, her, their computer and other devices copies of the photographs, videos of the plaintiff, Jane Doe, as the object of child pornography to other persons and themselves for their consumption. So they took these videos and photographs and fucking sent them to other people. So, Aaron, they're talking about these devices are found at his residence, which totally changes how I feel about some of that. They're found at his residence. If what they're saying is true, I mean, I believe her. So obviously, we're not going to see the proof of that. We're not going to see it. So we have to kind of just go with what we know now. He's not been found guilty of any of these. He's still pending trial, but in no way in hell is anybody going to force me to do that. No fucking way. No way. Okay. The defendant, Christina Parcell, aided and abetted and conspired with the plaintiff to take the inappropriate pictures and videos of the plaintiff, Jane Doe. The defendant's criminal, willful, reckless, and inappropriate sexual conduct towards plaintiff Jane Doe, including but not limited to photographing her in various stages of undress and videotaping of her being nude and sharing said videos, was without the consent of the plaintiff and a violation of the plaintiff's privacy. Such photographing and videoing is inappropriate sexual conduct towards the plaintiff and occurred during the time the plaintiff was entrusted in the care of the defendant. Now, if you think about this, you know, Christina's daughter was 9 at the time. And if they're friends, she's going to be around that same age. Yeah, there's years worth. They don't talk about that in this filing, not yet anyway. But the other filing does talk about years. Yeah, there's years worth of photos and videoing. I think that's in the daughters. We're gonna read that too. So the defendants committed acts of inappropriate sexual conduct towards the plaintiff's body, including but not limited to sexual misconduct and sexual assault and battery, sexual abuse, culminating in inappropriate sexual contact in the inappropriate undressing, touching, posing, and photographing of the plaintiff in sexually provocative positions in various stages of undress. By their conduct and their dominant positions as adults, defendants placed plaintiff in a reasonable fear of bodily harm if she did not comply with the defendant's requests and demands. I mean, yeah, she would have been like 8, 9, 10 years old. Yeah, chicken operas. Yeah, there's also, we haven't got to that one yet, but yeah, there's animal stuff. The touching of the plaintiff by the defendants before, during, and after the photographing and videoing of the plaintiff in the states of undress in sexually provocative positions was done with the intent of bringing about offensive contact upon the plaintiff. As a direct and proximate result of the above referenced acts by the defendants, plaintiff has suffered and continues to suffer economic and non-economic damages, including but not limited to medical, psychological, counseling, and related expenses, pain of mind and body, shock, emotional distress, fear, embarrassment, loss of self-esteem, humiliation, loss of enjoyment of life, damaged reputation, and other damages as yet undetermined. Plaintiff is reasonably expected to suffer from such damages in the future. Yeah, I'm sure that she's going to have she is going to deal with a lot of trauma from that. This is the intentional infliction of emotional distress, and it's going to cover the same things. The third one is negligent infliction of emotional distress. That's the third action. Same thing. Invasion of privacy. I think that one kind of covers itself. And then there's the relief. So that is like I said, that is the one from her friend, the daughter's friend. No, that's not the right one. That's not the right one. Where the hell is it? Is it this one? No, where? Maybe I didn't open it. Hold on, let me see. No, I never had it open. No wonder I can't find it. Okay, so now this is the one when Christina and Melo's daughter is taken from Lutina Parcell, after I think it was like 6 days of post homicide. When she's taken from her, she's put into foster care and she's put under the care of the Sutherlands. So this is now done by the Sutherlands as her legal guardians at the time. Let's make sure you guys can see that one. Okay, so this now is Jane Doe is a minor child under the age of 14. The plaintiff, Allison Sutherland, is the temporary legal guardian of the minor child and brings this action on her behalf as her next friend and as her next friend. I don't know what that means. And as her legal guardian. A petition to appoint the plaintiff as guardian and ad litem is filed herewith. The plaintiff and minor child are citizens and residents of the state. Brad Post, same thing, citizen of South Carolina. At the time of Christina's death, she was a citizen of South Carolina. And then here's the background. Hold on, I need to take a drink. This is literally the same reason I can't fucking handle it, covering Step and Stern's shit, because that guy's a piece of shit. And now I'm like, here we are with another situation of these sick fuckers that just do whatever they can to get their rocks off on fucking kids. Like, that's disgusting. I can't. It's so fucking gross to me. Hi, Ashley. No, this is of the daughter. Aaron, where's that at? Where can I watch that? Can you email it to me? Or just point me in the right direction? I'd like to watch that. Thank you. Okay, so the minor child was in the custody and care of Christina Parcell at the time of defendant Parcell's death on October 13th. Jane Doe and Christina Parcell lived with Parcell's sister, Lutina Parcell, from approximately April of 2021 until October of 2021. Christina Parcell was murdered in Lutina Parcell's home. Prior to Christina's death, the minor often spent time with defendant Parcell and defendant Post in Lutina Parcell's home. Next friend is like a guardian ad litem. Oh, it is? Okay. More of a child's representative. I guess I've never heard it called that. Upon information and belief during the course of the law enforcement investigation of Christina Parcell's murder, law enforcement discovered numerous photographs and videos of various minor children, including minor Jane Doe, in various stages of undress and in sexually explicit and nude positions, which had been taken over the course of several years. Upon information and belief, the videos and photographs of Jane Doe graphically depict her genitals and breasts. Further, petitioner is informed and believes that the photographs and videos of Jane Doe were taken by, with, and or in the presence of defendant Post and defendant Parcell. Upon information and belief, defendant Post aided, abetted, and conspired with defendant Parcell to obtain the inappropriate photographs and videos of Jane Doe. Jane Doe is a victim of child pornography perpetrated by defendant Post and defendant Parcell. All videos and photographs of Jane Doe were illegally obtained and taken without her consent. Upon information and belief, defendant Post, with the knowledge, consent, and assistance of defendant Parcell, duplicated photographs and videos of minor Jane Doe to a cell phone, computer, and or other electronic storage devices. The duplication of the sexually explicit photographs of Jane Doe constitutes violations of various state and federal laws, including child endangerment, sexual exploitation of a minor, criminal sexual conduct involving a minor, and constitutes child pornography. Plaintiff is informed and believes that the defendants knowingly and intentionally forwarded sexually exploitive photographs and videos of Jane Doe to third parties to be viewed and further disseminated for viewing by others. You do that to your own fucking kid. The defendant's criminal, willful, and inappropriate sexual conduct towards minor Jane Doe include, but are not limited to, taking sexually explicit and provocative photographs of and with the minor child, taking sexually explicit and provocative video recordings of and with the minor child, and sharing these images with third parties. Said conduct was a violation of Jane Doe's personal rights, including her right to privacy, as well as her right to be free from sexual exploitation and abuse. Multiple criminal charges are currently pending against defendant Post, which includes sexual exploitation of a minor, criminal sexual conduct with a minor, and possession of child pornography as the result of the defendant's abominable actions towards minor Jane Doe and other minor victims. So we're going to go into the same legal phrasing. So the first cause of action, hold on real quick, you guys, I have a tiny human. Okay, sorry. Upon information and belief that inappropriate conduct involving Jane Doe constitutes sexual battery, sexual abuse, sexual exploitation, all the same as the other lawsuit. Now, I believe that these are the same attorneys. Let me see. No, not the same. I lied. They just both started with an R, so it made me think they were. Okay, so that's the two civil suits against Christina Parcell's estate and Bradley Post. I'm still gonna go. I'm not as much as I hate this. I don't think the jury should know about this if we can't show that there was any claim of this prior to the murder. I think that's the most important thing. If they knew about this prior to the murder and they can prove that, then yes, I think it should come in. That's where I'm still gonna stay with. If they don't know this, then it has nothing to do with the murder. And not to mention, you still can't have Zach Hughes just going over there and killing her, even though I'm not necessarily opposed to it if I did know it. I know that sounds fucking terrible, but all right. All right, let's go. Now we're going to look at, this is Melo's federal complaint, his lawsuit against the two investigators and the guardian ad litem. The thing is that Melo claimed SA prior to the murder, but not CSAM. So here's a catch-22. Let's look at this on the factual side and not the emotional side. You look at this on the factual side. If Melo is claiming SA against his own daughter, and he is fighting for custody of her because of this, right? Then you give Melo motive, and if you have Zachary who's in some love relationship, whatever you want to call it, you're giving him motive. Well, he's not saying he did it out of any type of crime of passion or anything along those lines. He's claiming he's innocent and had nothing to do with it, and he wasn't there. So I don't know that the defense would necessarily, I mean, if you fight to have those statements by Melo brought in, you essentially are giving Zach motive, which juries like motive, even when you don't have to have it on the legal side. I just don't know how that would benefit Zach, besides, because there's no proof of it up until the CSAM is found after the murder. So, I mean, yes, of course he believes his child, fine. I would absolutely agree. But you give Zach motive, and Zach isn't saying he was there. Zach's saying he didn't do it. So I just don't know how that would play. I don't know how that would work for Zach's benefit. Now, the CSAM, on the other hand, I could see, because what that does is brings in the third party, where there's other victims of these people, and now somebody else might be the one who goes in and does this. So it's almost like him claiming SA doesn't really help Zach. It almost kind of would hurt him in that, or could hurt him. I'm not saying does hurt him. It could hurt him because it gives him motive. Susie Q, I have all three of them on the thumbnail, but I'll show you this too. This will help. I think the CSAM would be the most beneficial to Zach's defense. But if they don't know about the CSAM, then it doesn't really help, because you can't really create third party. I don't know. I think you're kind of caught in like a catch-22. It gives post motive? It's okay, Susie. I put it up so you guys can all see. Everybody wants to know all those anyway. So here's your victim, Christina Parcell. Here's the boyfriend that gets all the CSAM charges. This is Bradley Post, who's in his, I think one of them is in their late 60s, one's in their early 60s. I'm going to probably mix up which one is what. And then here's John Melo, which is her daughter's dad. And then here's Zachary Hughes, who is the defendant. So Patricia, why do you say free Zachary Hughes? What's your thought on it? What's your thought on the why? That's kind of what we're discussing, is like, what What did they show? What didn't they show? And what would the SA allegations versus the CSAM allegations prove? So what's your thought? You're on the free Zachary Hughes side, so I'd love to hear your thoughts. How do you know that Melo and Hughes were lovers? I don't know they were lovers. I said they had some type of love relationship because they're saying in their email communications that they love each other. We don't. It was rumored and insinuated that they had a sexual relationship, but that's never confirmed. They just talk about how they say they have some type of love relationship. We've actually speculated, is there more of a connection possibly between Zach and Isabella? Thank you, Aaron. Thank you. They were telling each other, "I love you" in the messages. Yeah. Why not? Well, I was just curious on what your thoughts were. Like why you thought that. That's okay. You don't have to share. All right, let me pull up my email real quick so we can see this before we go into.
Breaking news out of Greenville County, where a judge has.
Hold, please. I gotta pull it up.
Child with a woman who was brutally killed.
It's a case that goes back to 2021.
Yeah, and the judge dismissed the case. This is John Melo that you're looking at right there. He is facing the charges that we are discussing in this case. Authorities arrested John Melo for interfering with a custody order back in October of 2021. Opening statements in the case started yesterday.
Now, Melo shared a child with Christina Parcell, who you see on the screen. She was found stabbed dozens of times at a home on Canebrake Drive in Greer in October of 2021. Melo was charged with taking their child out of the country, but he claims Parcell's fiance was sexually abusing the child. Melo previously filed a report to police. No charges came from that report, but Parcell's fiance was arrested on charges related to child pornography in the weeks after she was murdered.
Our investigative team has been in the courthouse since the start of the custody trial. Fox Carolina's Grace Runkle joins us live from the courthouse with an update.
Yeah, a very quick end to a case that took about 2.5 years to actually come to trial. The defense asked for a directed verdict after the state closed their case, and the judge granted it, meaning the case is now dismissed. Now, a directed verdict is something that the defense can ask for in any case. It's basically asking the judge to rule that the state did not adequately present their case, and today the judge agreed, saying the law John Melo was charged with breaking involves a child being taken from a legal custodial parent, which the judge says Melo could not have done because he was the legal custodial parent. Melo's defense in previous filings has been that he took his daughter out of the country to protect her from abuse, he says, at the hands of her mother and her mother's fiance. However, they did not have a chance to present that side of the case today, but we spoke with Melo's attorney after the judge handed down that directed verdict, and he said his client is relieved.
And when you do something that for the right reasons and you sort of get punished for it, I think it's hard. It's hard to deal with. And I think that this is just a culmination of waiting for this day to come for so many years. I mean, the prosecutor's office really took a while to get this up here. So anyway, we're very relieved.
But before that happened, we heard from Melo's daughter, and because she's a minor, we're not using her name, we're not showing her or even using her voice, but we will show you what she said in court. As soon as she took the stand, the state asked what happened in 2022, and she said, quote, "We moved to Italy. It was the best thing that's ever happened to me." And when the judge granted that directed verdict, we heard Melo kind of gasp in the courtroom, clearly very relieved, kind of put his head in his hands in awe that he got that directed verdict so quickly after waiting so long to get to this point. And he currently has custody of his daughter, and at this point, it's going to stay that way. Live in Greenville, Grace Runkle, Fox Carolina News.
Grace, thank you. And right now,
Interesting. So the daughter testified and said that moving to Italy was the best thing that ever happened to her. And the judge, well, they ruled that in South Carolina, because he was actually the custodial parent, Oh, I still think he's terrible. I still think I don't. I think he's I think he's. I think there's definitely something wrong with Melo, without a doubt. I still don't think he's a good guy. Now, does that change that part of it? No, not necessarily. Oh, so she would have been, at the time of that hearing, she would have been 11, 12-ish. Yeah, I know. I got you, Aaron. I agree. Pastor Judy fell asleep. I guess I wasn't that exciting over there then. So what if speculating Zach was essayed himself as a child, and once Melo told him about it, that was his motivation? I mean, it's possible. We do know that Zach's family was actually from California, and then when they moved over to South Carolina, they ended up adopting, I think it was 5 Russian siblings, who all had trauma, major trauma in their lives, and so he was like a huge support to these 5 adopted children. Okay, so this is the lawsuit from Melo against the investigators. So we'll read that. So this is the defendants are Matthew Anderson and Robert Perry. I do not remember either one of those specifically testifying or not testifying. I couldn't put a face to either one of those if you wanted me to. I don't think he knew about the CSAM. So far, what our understanding, Boo, is that he made essay allegations, and the CSAM is, I think Sleuthy said it earlier, the CSAM is just the recordings of them doing the essay. So not to say that it's not. I just, if Zach is trying to say like he didn't have anything to do with it, my point is that the essay allegations from Melo give motive for Zach and Melo. The CSAM, on the other hand, having other people involved, gives the option for third party. So I'm just like saying, if I was like the defense attorney here, I don't know where I would draw that line at. How much do I want in? How much do I not want in? You know what I mean? Aw, Journey. They crossed the pond. Okay, so Matthew Anderson, Robert Perry, I'd have to go back and look and see if those were either any of the ones that actually testified. The other defendant is Vanessa Cormiello, and she's the guardian ad litem. She did testify for sure. We know that. Okay, so during the time period in question, the plaintiff's constitutional rights were well established and well known to each of the defendants listed above, including but not limited to the plaintiff's right to liberty. Okay, so then they're going over jurisdiction. It's South Carolina. Everybody's a resident of South Carolina. Wants a jury trial. Here's your allegations. So plaintiff and Christina Parcell, so John Melo and Christina Marcel, who were never married, are the parents of one minor child born in 2012. In October of 2015, the plaintiff filed for custody of his daughter. On January 4th, 2016, plaintiff was granted sole custody of the minor child in the Pickens County Family Court. Now, this was a huge question. Why in the world was he granted custody to begin with? I don't think we've heard that yet from anybody. Later in 2016, Ms. Parcell filed for visitation, and on August 10th of 2016, a visitation order was granted. 8 months later, was granted with a visitation schedule with the minor child and Ms. Parcell. However, sole custody remained with the plaintiff. Melo's oldest child wasn't in foster care. She ended up being the guardian, the legal guardian of her younger sibling for a while. Okay, so that's Exhibit B. In 2017, plaintiff filed to revoke Ms. Parcell's visitation due to suspicions of sexual inappropriateness and or abuse while the minor child was with Parcell and her then boyfriend, Bradley Post. So that's back in 2017. From 2017 to 2019, the plaintiff continued to try to remove his daughter from having visitations with the mother due to continued allegations of sexual inappropriateness and abuse. He contacted law enforcement and the Department of Social Services regarding his fears for his daughter's safety, but was unsuccessful in retaining any help. Why aren't they putting any exhibits in for that? Why don't 12 and 13 have any exhibits attached where he was filing these complaints? There's got to be some documentation to put in here, right? That's what would be important to me. On January 28th of 2019, plaintiff and Ms. Parcell agreed on Ms. Parcell's visitation schedule. The plaintiff was again granted full and exclusive custody of the minor. The agreement was made into a final order in Greenville County Family Court and filed on February 4th, 2019. However, plaintiff continued to suspect that his daughter was in danger while visiting with her mother. See Exhibit C. Okay, so there's one that might possibly have something. I think so, passenger. That's what it seems like. Or they're just sending it to their friends. I don't know, but there's both the civil suits allege that they were sending it to third parties. Snappy. I know that's a lot of people agree with you. A lot of people agree with you. And I think that's why the prosecutor was like, we don't want any of that in. On or about October 4th of 2020, the plaintiff, who is also a citizen of Italy, moved back to Italy with his daughter due to continued concerns of sexual abuse of his daughter. At the time of the move, plaintiff had full and exclusive custody of the minor child. On or about October 30th of 2020, Ms. Parcell filed a rule to show cause alleging the plaintiff was not allowing the visitation order from the February 4th, 2019 family court order. At the hearing that was held on or about December 16th, 2020, without the plaintiff being present, Ms. Vanessa, the guardian ad litem, was appointed the guardian ad litem for the minor child, and plaintiff was found in contempt of the visitation order. On or about April 14th, 2021, the minor child was ordered to return to the U.S. by the Italian Central Authority pending resolution of the U.S. family court matter. See, there's exhibits for that. This order was eventually overturned, which we just watched. On or about April 19th of 2021, an indictment was issued for the plaintiff on the charges of custodial interference and signed by the Assistant Solicitor Ryan Holloway. Neither Officer Matthew P. Anderson, Officer Robert Perry of the Greenville County Sheriff's Office, nor any member of the Greenville Solicitor's Office informed the grand jury that the plaintiff was the minor child's sole custodial parent. So on July 21st of 2021, an arrest warrant was sought by the Greenville County Sheriff's Office, specifically Officers Anderson and Perry. Defendant Vanessa instigated the arrest of the plaintiff by consistently reaching out to Greenville County Sheriff's officers requesting the arrest of the plaintiff despite knowing or should have known that plaintiff's actions did not violate any custodial orders. Well, from the sound of her testimony, it's like he was harassing the shit out of her and she wanted him arrested. Nothing about supervised visitation. No, there's nothing supervised. Nope. And that they agreed upon it in court in 2019. So he has these accusations of SA, says nobody's doing anything about it, and then he goes to court and agrees on visitation. Like, that's fucking weird too. Why would he go in 2019 and agree if he thinks that she's being sexually assaulted? Why is he agreeing for her to go and not under supervised? I don't know. That's weird to me too. Okay. The arrest warrant was issued even though both officers knew that he was the sole custodial parent. Officers Anderson and Perry never made the judge issuing the warrant for plaintiff's arrest aware that he was the custodial parent of the minor child. Mr. Melo was still in Italy at the time the arrest warrant was issued. On October 13th, 2021, Christina Parcell was killed. During the investigation of Ms. Parcell's death, photos and other proof substantiated plaintiff's claims that the minor child was being sexually exploited by her mother and her mother's boyfriend, Bradley Post. So a lot of typos in this. He can't be live yet. He's not supposed to be live. I have it set up for... He's not supposed to be live yet. Oh no, he's live on the Songbird. Right, that one? No, that's tomorrow. He's not live. What's he live on? Oh, he is. What the hell, Bob? All right, well, I'm gonna have to catch up on that. No, I didn't fuck up on the time zone. It said 6:45, and when I go onto YouTube, it says 6:45 my time. 6:45 p.m. 2/17. He's doing a pre-live. Yeah, it's not even. This one's not even live. Yeah, no, he's live in 2 hours. It says. Yeah, he's just in his.
I love defense attorneys.
I love defense.
I'm trying to get treated.
Okay, so he's just doing a pre-show. He's just doing a little pre-show. Hi, Sleuthy.
Hello, it's no big deal. He's just letting everybody know that I guess Andy's gonna get on the live with him tonight.
Perfect.
Waste of time.
And so I was like, wait a minute, he's not supposed to be live yet. That is like really throwing off my whole thought process on the schedule.
Yeah, no, that would be way too early. Plus, I think all his mods are in here right now.
Yeah, they can't go. He can't go live. We're busy.
Yeah. No, I'm
Totally
enthralled in this. So do you feel like you've gotten, well, so it's difficult, right? Because nobody's been convicted of anything yet. And I think.
Yeah, but there's obviously pictures. I mean,
Dude,
I don't think there's any way around it. Hi, Hellas peoples. Thank you guys for jumping in.
Yeah, it's
there's
difficult.
obviously pictures. There's no doubt in my mind that there's something really bad happening with these kids. Like, I just don't have any doubt about that. My biggest question, well, I had two really. The biggest question was, how much can they prove that Christina and Brad had to do with the photos? Because I'm not above the. I'm not. I don't think Melo's above planting shit. I just don't. Now the fact that the stuff is found in Post's house versus her house,
Yeah,
is different, because that was the impression that they gave, was all those hard drives and thumb drives were found at the crime scene. And I'm like, that he could just go put whatever the hell he wants in there. The person who did this, you know what I mean? They could just go drop whatever they want around this house.
yeah. Are you not suspicious of the Isabella thing? I could make more reasonable scenarios in my head about him doing this if he did it, and even like the way. So remember when you were like, they were saying they loved each other on the emails or whatever, and I was like, that's weird. And you were like, well, maybe they're just like, friends. They just like have love for each other or whatever. I was like, nah, that's still weird. Like, I don't know any guys that do that. And you're like,
right,
well, we do it. I'm like, we're not guys.
Yeah, we're
like,
girls. No, that's always that. And it's typically like a bro thing. Like, love you, bro.
Yeah. So
they have like a guy code of how they say things like that to their bromances.
What is the possibility of her being the one that was talking to him via email?
Okay, so hold on. I'm gonna give the skinny on it for skinny, and anybody else who just popped in, because this is a case that not everybody's overly familiar with. But we're in the midst of watching a trial in South Carolina. They had no court today, but the trial is, the defendant's name is Zachary Hughes. The victim is Christina Parcell, and it's got a lot of twists and turns in it, because there was a huge custody battle with her ex. So Christina Parcell is the victim. Her ex, John Melo, had a huge custody battle with her going on, and was doing things with his quote unquote friend, Zach Hughes, who is the defendant, to harass the shit out of Christina by taking old nudes of when he was with her, and they were like setting up profiles on escort sites with her old nude photos. And just doing anything they could to harass her, and then send it to the attorneys saying, here, look, she's a really bad mom, and she shouldn't have custody of my kid, and I should have custody. Now, Christina is, at the time of her death, was dating a gentleman named Bradley Post. Bradley Post is the one who found her and called 911. 6 days later, they take his phone, and what they find on his phone is CSAM, which includes the minor daughter of Christina and John. They go and search his house, and they find hard drives, thumb drives, all kinds of stuff downloaded on his computer, where they're sending these photos of the minor daughter and the minor daughter's friend to other people. So we're discussing some of the backstory of the case based on the father's accusations of SA, and then the CSAM that's found after the murders. So that's kind of the gist of it. So a lot of people out on the interwebs almost feel that Zachary Hughes is justified if he did do it, because she was allowing and participating in the CSAM of her own child and her friends. John Melo does end up getting custody of the daughter back. I think that's probably the shortest version of this I can give. Did I miss any of the major points?
No, probably not.
She was a vet tech, and they also accuse her of...
Oh, did we even get to that part yet?
We haven't got there yet. She's a vet tech, and they accuse her of... accuse her and her fiance, Bradley Post, of doing stuff with animals. We haven't got to that part yet, though. So... it's a fairly short trial. It's happened October, the crime itself happened October 13th of 2021. They have ring camera footage of a gentleman in a gray sweatshirt with a backpack entering her home shortly after she arrives back home after a job interview. And then they have other surveillance footage of a gentleman wearing a black sweatshirt riding a bike, leaving the area of the crime. And then they have traffic cams of Zachary Hughes's truck with a bicycle that resembles the bicycle from the surveillance cameras in the back of his truck. The last witness for the state testify was the ME, and then the DNA analyst testified that they did find DNA of Zachary Hughes under the right hand fingernails of Christina Parcell. The defense attorneys claim that it was due to cross-contamination because the serologist was getting everything ready to send over to DNA, and she was doing the evidence and the buccal swabs of Zachary Hughes at the same time. So the defense is alleging that there's cross-contamination. You want to see the photos? I'll show photos real quick too. Okay, hold on. So this is, and it's called the rose petal murders because whoever committed the crime left rose petals all over the crime scene. We don't know if they brought the roses, if they knocked over the roses, but there was no vase and no water found. Okay, so let me see. Where's the first one? Why don't I have that one? So here's the guy on the bike. I don't know why I don't have. It's got to be somewhere. I must not have moved it over to this file because I don't have the one of him going into the house for some reason, which doesn't make sense. Okay, so here's a guy on the bike. It's caught on 2 different cameras. So there's the guy on the bike, and then here is, I'll find the other one because I have it. I just don't know where the hell I put it. Here is his truck with a bike that resembles it in the background. And then at his home, they find the bike in pristine condition. They say it's super clean. Crime scene. This is the crime scene. So you can see rose petals all over. See, her purse is right here. There's rose petals inside of her purse. There's rose petals all over the place. They have him at a cabin that out on trail cams a couple days before, wearing a black sweatshirt that has a gray interior, and so they're stating that it's potentially like a reversible jacket, and that so the person going into the home was wearing gray, and they just simply turned it around, and it was black on when he was riding the bike. All right, hold on. I gotta find the other photo real quick. I don't know why it's not in here. Anything you want to add to that?
No. That doesn't even look like, I mean, like it does look like him, but it doesn't look like him. It's bizarre. It feels very Brian Laundrie.
It does, right?
It looks like I don't know, man. Also, like, did he not notice any cameras? Like, he's 5 feet from the camera.
The trail cam?
Yeah.
Well, I don't think he cared about the trail cam. For one, this is from the 11th, and the crime happens the 13th, so I don't think he actually cared about it.
Oh, so the
So here's
reversible thing, well, I think that was like a really, really good idea. I find it kind of bizarre they didn't like bring in a jacket. Like, did they not find?
no,
Did
they
they
didn't.
do like?
They didn't find a backpack. They didn't find the jacket. They didn't find the hat. They didn't find the gloves. Nothing.
I mean, did they even do like a search warrant of his house? I might be drawing a blank because I'm sick.
Not according to what they talked about in the state's case so far. No.
Well, the case is over. The state's case is
I know.
over. That's weird. I know they did the car or the truck or whatever, but that's weird.
So,
Like, if
yes.
you had the jacket, like, and it
Well,
was a
the only
reversible
thing they
jacket.
say, well, they did do the search of his house. They do talk about that because that's where they find the bike.
Oh,
That was the big thing they found at his house was the bike.
and you said there was a burn pit too.
The burn pit is out at the cabin where the trail cam is from, and then they have in his truck they find the 6-pack of gloves that's missing one set of gloves.
Well, so the reason that's doesn't work is they didn't find her blood or anything, her DNA, on like the handlebars of the bike.
No.
And remember, you were like, so what, did he like change his glove? Which is reasonable, like that after he was done, he changed the gloves because he was wearing the gloves in the video of him on the bike. So he would have changed his gloves. That's why her DNA wasn't there or whatever. But there was only one pair missing. So that couldn't, it's not what he did. But also, who buys like gloves and doesn't at least use a pair for any normal reason? You know what I mean?
Right. You're going to buy the gloves.
So I think that's strange. It's literally just like the pictures of him walking through the woods, right?
Mm-hmm.
Which is not like at her house or nothing. And the DNA under her fingernails, but did they even say like what that was? Was it skin? Like if she was fighting him?
I don't think they said what type of DNA it was. I don't recall that.
Yeah. It's just
strange. Just that they swabbed the fingernails and that's what they got.
And they did find his DNA like on the handlebars and whatnot, right?
Yes. But they also said that the bike was cleaned.
Cleaned and then used?
Well, apparently. Cleaned and then
because it has DNA on it.
Right.
What about in the truck?
No.
So like, so he drove, so the idea is, right, correct me if I'm wrong, that he drove the truck somewhere with the bike in it. Or wait, was that for the harassment thing? Did they catch the truck with the bike in the back for the harassment stuff?
They track his cell phone to the locations of the mailboxes where the photos were sent. So they sent those nude photos to all kinds of people, her job, her sister's job, the neighbors, and they were all mailed from different places, and they tracked his cell phone to the mailboxes that those were all from.
Oh, I definitely think he did all that shit. I mean, they don't need to do nothing further to convince me about that. And I
Right.
also could justify that, like, for your friend or whatever. I mean, you're insane to do that, but that's not murder. So I don't think they need to tell me nothing more about that. But the murder stuff is still just strange to me. But they have whatever this DNA is under her fingernails, like, he's cooked.
Right.
So
I think so, unless the defense puts, and like I said, I know that the defense doesn't have to do anything, but unless the defense puts somebody on there that talks about like statistics of cross-contamination or why they don't have serologists doing the buccal swabs at the same time that they're processing evidence, other cases like he just, I don't think he drove that home enough to the jury to say, hey, you have this massive crime scene, there's blood everywhere, and that you're saying that she fought back, yet there's only a minute amount of DNA found under one set of fingernails.
yeah.
Let me see. Is there a
I mean, I
legit
don't think
reason?
it's gonna matter.
No. They've never met. They have no communications whatsoever. When he was arrested, nobody even understood how he tied into the whole thing.
Yeah.
They ended up finding out that he was connected to the ex-husband, or he's not a husband, the baby daddy.
Through the guy who testified and said that he thought it was a good person.
Yes, Michael Mangione or whatever his name was. Okay, so I think that kind of gives you guys the rundown of everything. Why is it not wanting to let me out of that? So now we're just going through some pre-trial stuff that goes through the charges against Bradley Post and Christina Parcells, and now her estate that her sister's in charge of. So we're just kind of looking at that to see whether it should or should not have been brought into court. So all the CSAM was ruled by the judge to not be allowed to come in. And so this is right now we're reading through a federal lawsuit that the daughter's dad, John Melo, filed against his daughter's guardian ad litem, who did testify, and two of the investigators. That's where we're currently at, that you guys have joined us. So, well, that's Sleuthy, I think, that did that, because I think she's sus of Isabella.
I'm super sus about that whole situation. For whatever reason, like, my ears perked up when they said about her and that he called her before and after the murders and stuff.
Right, he does call. So Isabella is the older daughter of the baby daddy. So it would be Christina's daughter's older half sister. He lived in someone else. He rented a room in their house. I think that he was close with that family. And they were in another country, I think, at the time, and so they gave all permission to search anything that was theirs. Okay, so on October 13th, Christina Parcell was killed. During the investigation of Miss Parcell's death, photos and other proof substantiated plaintiff's claims that the minor child was being sexually exploited by her mother and her mother's boyfriend, Bradley Post. In October of 2021, Bradley Post was arrested for sexual exploitation of a minor and child pornography related to his and Miss Parcell's abuse of the minor child. On October 20th of 2021, the plaintiff returned to the United States in order to retrieve the minor child after the death of her mother. On or about November 3rd, he's arrested. As soon as he lands, they don't put that in here though, but he was arrested when he landed. He was actually taken into custody and then arrested on the 21st. But on or about November 3rd, 2021, Zachary Hughes was charged with murder of Miss Parcell, and his phone was seized in connection with the murder for further investigations. Zachary Hughes's phone was locked with a military-grade encryption, and it would take the Greenville Sheriff's Office over 9 months to unlock it. On October 21st of 2021, the plaintiff was arrested for custodial interference by Charlotte police after returning to the States due to the arrest warrant initiated by the Greenville County Sheriff's Office. When the warrant was sought by the Greenville Sheriff's Office, the magistrate was not informed that the plaintiff was the sole custodial parent of the minor child. On October 21st of 2021, the plaintiff was wrongfully arrested by officers of the Greenville County Sheriff's Office on charges of custodial interference. This charge was based on the false premise that plaintiff violated a custodial order, even though plaintiff was fully compliant with all existing family court orders regarding custody. I think he's trying to say because they came to an agreement, but once it's an agreed upon under the court and the court puts it down, it is official with the court. So, but he's still the primary custodial parent. Officers Anderson and Perry, solicitor Walter Wilkins, and assistant solicitor Ryan Holloway became obsessed with the plaintiff and the idea that he murdered Miss Parcell. Officers Anderson and Perry, in conjunction with the Greenville Solicitor's Office, began to use the arrest for custodial interference, even though plaintiff was the custodial parent of the minor child, to prevent the plaintiff from returning to Italy. Officers Anderson and Perry, in conjunction with the Greenville Solicitor's Office, prevented plaintiff from returning to Italy in the hopes that once Zachary Hughes' phone was unlocked, they would have the evidence implicating the plaintiff in Miss Parcell's murder. Zachary Hughes' phone was eventually unlocked, yielding no evidence that the plaintiff was involved in the death of Miss Parcell. I don't know if I would say that there's no evidence, but it is minimal. It is minimal. I mean, the fact that they're talking on WhatsApp and they literally stopped talking the day of the murder on WhatsApp, I think there's something to that. And they talk on the phone for an hour and 20 minutes after he kills her, or supposedly kills her. On September 26th of 2022, the defendants were made aware that the plaintiff could not be guilty of custodial interference because Miss Parcell was not a custodial parent. The Greenville Resident General Session Judge signed an order stating that Miss Parcell does not meet the definition or is otherwise exempt from the definition of legal custodian. See, this is where you still can't interfere with people's visitation legally. Nonetheless, defendants did not terminate the prosecution of the defendant, instead attempting to appeal Judge Kinlaw's order. After 8 months of an additional delay, the South Carolina Attorney General's, the agency who appeals on behalf of the state of South Carolina Law Enforcement Office, refused to continue the appeal. Nonetheless, defendants did not terminate the prosecution of the defendant, instead proceeding to trial in front of a different General Sessions judge. On October 16th of 2024, the plaintiff was exonerated of all charges by a directed verdict stemming from his October 20th, 2021 arrest. An order for the destruction of his criminal record stemming from October 21st arrest was entered on or about August 19th of 2024. The defendant's solicitor's office, upon review of the matter and charges, continued to prosecute against the plaintiff, failing to present exculpatory evidence to the grand jury showing that the plaintiff was the sole custodial parent at the time of his arrest. The charges were initiated by the Greenville County Sheriff's Office without probable cause and with malice, and were based on false, misleading, or insufficient information. The defendants knew or should have known that there was no legitimate basis to arrest or prosecute the plaintiff, yet they proceeded with the prosecution anyway. As a result of the malicious prosecution, the plaintiff was subjected to arrest, detention, bail conditions, and other consequences, causing the plaintiff to suffer great emotional distress, humiliation, and financial loss. The actions of the defendants were intentional, willful, and in reckless disregard of a plaintiff's rights, and were carried out with malice and an intent to harm the plaintiff. As a direct and proximate result of the defendant's gross, negligent, reckless, and unlawful conduct described above, the plaintiff suffered damages including but not limited to pain, suffering, emotional damage, and such additional damages as may be revealed during the trial of this matter. All right. I don't know. I think I don't know how I feel about that. How do you feel about Melo suing them for arresting him?
Melo suing them for what?
Arresting him and causing all this emotional distress.
Well, what's confusing about that is that he was the custodial parent. What was the reason that they gave for why they like what?
Because he took her to Italy and kept her from her mom during the court mandated visitation.
Okay. I mean, was she getting all the visitation? Was she taking all the invitation? I mean, it doesn't matter though. I don't know. I think he's petty, but I don't know. I have a different opinion of it. Thankfully, my kid wasn't going through anything like that, but I have my own opinion about this kind of stuff and just the family courts in general,
Yeah,
and what they do to people, so, and how they make people. You know what I mean?
true. They push for certain things to be done. You know, family court, family attorneys do the same.
Okay, like for
October 20th.
example, mine. Well, I've told you the whole thing about, like, they had documented evidence, photographs, videos, all kinds of things of him doing stuff with my 2-year-old in the car, buying stuff with my 2-year-old in the car, and
Mhm.
nobody seemed to care. And in fact, they kind of look down on if you say, like, one would consider that disparaging, and they'll actually like look down on you for that. And fast forward all the way like 2 years later, my ex-husband told me that if I like waived child support, if I told them I would not collect child support, then he would just let me have him and like stop fighting me, because they were only, it's a long story, but he and his family were only fighting me for 50% custody so he would not have to pay child support. So when I said that I wouldn't, we got divorced like immediately. Like, he was like, okay, if you're not gonna come for child support, then you could just have him. And so we told the judge that it was just me, him, and the judge on the day that like it was finalized. And she straight up heard from his mouth that was the plan that he had agreed to. And she said to me, she's like, are you sure? She's like, well, regardless, you know, if time goes by and you need help, like, you can always come back and request child support. And so I'm thinking, okay, like, now I'm going to have him, no more arguing. And I can do what I need to with him. I could take him where I need to go. You know what I mean? Like, like, we can be free of this craziness, and I don't have to worry 3 days a week, because I was sick. I mean, I was sick when he would leave my house, sick. And so the judge was like, well, he doesn't have to see him every other weekend. But that's like the minimum that, like, that's the bare minimum that I can give someone. And whatever, like, I take from him now. So if I give you full custody of him, it's going to be harder for him to see him in the future should he decide he wants to. And I'm like, huh? She's like, so he's going to have visitation every other weekend. That way, if he does want to have him, he doesn't have to like take you back to court. And I just thought, okay, so now you're hamstringing me and my 2-year-old, and I can't do what's best for the two of us, because just in case sometime 10 years from now, if he decides he wants to start seeing him every other weekend,
Right.
I have to be here to be able to make sure that he can have him. I mean, that's craziness.
Sign over his rights completely, and then you wouldn't be able to do anything one way or the other.
He didn't. He wouldn't.
See, that's what I would. I think the only way that would work.
Yeah.
But I mean, you also don't necessarily want that, because you don't want your kid to never see their dad. And I don't know. That's a catch-22. That's a tough one.
Yeah. So I'm just saying that they do make people, like, I don't know. So I have my own personal opinion about all these things.
Right.
I still wouldn't kill him. You know what I mean?
Well, I mean, I guess if you thought that he was actually essaying him.
Oh, well, yeah. I mean, like I said, thank God.
We might figure something out.
Yeah.
So Nursery Dog Mom says you don't send thousands of messages a day to your bro and say I love you, and then say well, he also says like I love you back.
No, but you might tell your girlfriend that. I'm just saying.
Love you back.
Your girlfriend on her dad's email or something. I don't know.
Hey, Weeshite, thank you for all your work and your coverage, T. You're very welcome. Thank you, thank you. Okay, so this is the motion in limine. Now we're back to the actual defendant in the criminal case. Motion in limine filed to exclude the reference to and the evidence of the child pornography. So October 13th, Parcel's killed. Parcel was involved in a custody battle with the child's father, John Melo. Melo is alleged to be an associate and close friend of the defendant. Based on the evidence that the state intends to introduce at trial on April 17th of 2021, Melo texted the defendant through the WhatsApp to harass the shit out of Parcel. On May 16th of 2021, Melo, through his email, received 2 sexually explicit photos of Parcel, and subsequently, this is not Melo, this would be Hughes that received them from Melo, so that's wrong. Received 2 sexually explicit photos of Parcel and subsequently distributed those images. Oh, never mind. I guess he received them through his email. Hold on, I'm going to reread this. Melo received through his email 2 sexually explicit photos of Parcel, and then he distributed those images to the defendant.
So who did he receive the emails from?
That doesn't even make sense. They're his photos. So yeah, where's he receiving them from? I know where you're going. I know where you're going.
Oh dear.
Okay, so Melo sends them to the defendant, which we knew, but I don't know this whole through his email. In July of 2021, packages containing said photographs were mailed to Parcel, her employer at the time. Post, which is Bradley Post, 2 of Parcel's neighbors, and an Outman Cigars and Martini bar, a bar that both Post and Parcel frequented. Post and Parcel were involved in a romantic relationship leading up to Parcel's murder. Post, upon returning to the home on Canebrake Drive on the morning of October 13th, discovered Parcel's body and notified police. Parcel was the only individual in the home at the time of the murder, as their daughter was at school. Pursuant to what he informed investigators, Post had come to the Canebrake home that morning after Parcel had not returned texts and calls. Law enforcement interviewed and met with Post on several occasions in investigating the murder. In the course of that investigation, specifically in determining his whereabouts during the murder and potential involvement, Post relinquished his phone and his electronic devices, leading to the discovery of a high volume of child pornography on these devices. Post was arrested on October 19th and faces 6 charges of sexual exploitation of a minor, which I think it's actually 9 now, if my research is correct. Exploitation of a minor related to that electronic material. Those charges remain pending with the Attorney General's office. Based on the phone extraction, Post's text and call history confirm his communication with Parcel that morning. Further, Post Life 360 app places Parcel's arrival at the home at 9:07 a.m. The murder investigation led law enforcement to a Ring camera located across the street from her home, which recorded and confirmed Parcel entering the home at 9:07, followed by an individual entering her home at 9:15 with a gray hoodie and a black backpack. Ring cameras record in-motion activated clips as opposed to continually recorded devices. Parcel's body was discovered about an hour later by Post as he placed a 911 call at 11 a.m. Parcel was stabbed approximately 31 times, and those stab wounds were the proximate cause of her death. Another Ring camera later videoed the suspect leaving Parcel's neighborhood while on a bicycle at 9:27 a.m., dressed in the same clothing described above, with a face covering, N95 mask, and a hoodie over his head. I do not agree with that at all. It is not the same clothing. I mean, it could be the same clothing, but it's not the same colors. It does not match. There's no gray. It's not a gray hoodie and a black backpack. It's a black hoodie and a black backpack, and it looks like a gray beanie on his head or a gray hat. We need to bring Disney and NASA in. A Ring camera at 116 Canebrake records Post's vehicle driving towards the home at 10:57, while the 121 canebrake ring footage shows post vehicle at the house at 11:05, the same time law enforcement had arrived. Prior to that, the 121 canebrake ring camera does not show post vehicle at the residence. Upon first responders arriving at the home and contacting Post, he was in a sport coat and khakis. Subsequent searches of his home revealed no matching clothing to the suspect or any evidence that would suggest he was involved in the murder in any capacity. On running a complete diagnostic of Post's phone and electronic devices, no internet search, communication, or mention of a Zach Hughes or Zachary Hughes was found. In learning that the defendant had a relationship with Melo, they don't say what it is, law enforcement began reviewing flock cameras in Greenville County. Flock cameras are license plate reading cameras that store every passing license plate in a searchable database with time, date, and photo of the car. The flock cameras are located throughout Greenville County. On the day before the murder and the day of the murder, flock cameras displayed defendant's truck with a bicycle located in the bed of the truck. I don't think they told us about the day before. We didn't hear that in testimony. What year is this? This is all 2021. This bicycle matched the description of the bicycle that was leaving Parcells' neighborhood at the time of her murder. Law enforcement executed a search warrant on 122 Tyndall Road in Greenville, the home in which the resident was living, and located a bicycle matching the same description as the bicycle located in the back of the defendant's truck and photographed on the flock cameras. A witness in the defendant's home stated that the defendant owned the recovered bike and that he had recently used it. Subsequent DNA analysis on multiple locations of the bike confirmed the presence of the defendant's DNA. DNA analysis was also conducted on Parcell, where a positive match was identified under her right fingernail to match the defendant at a rate of 825 million times more likely than a coincidental match to a random unrelated individual. The defendant was arrested on November 3rd and was subsequently charged with murder, possession of a weapon during the commission of a violent crime, harassment, conspiracy, and burglary in the first degree. The argument is the child pornography evidence is not relevant to the defendant's charges. Any evidence relating to Parcell, Post, or the daughter regarding allegations of creating, participating in, possessing, or distributing child pornography is not relevant to the determination of whether the defendant committed the murder of Parcell on October 13, 2021. More specifically, the evidence has no tendency to make the existence of a fact that is of consequence to this murder more or less likely. Nor is there any evidence to show that this potential involvement in child pornography would assist the trier of fact in determining the question of who committed this murder. Relevant evidence is that which has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Another way of determining relevance is if the evidence would assist, quote, a jury at arriving at the truth of an issue, unquote. As a general rule, all relevant evidence is admissible. The defendant is charged with murder, possession of a weapon during the commission of a violent crime, conspiracy, harassment, and burglary in the first degree. For all charges, Parcell is the sole victim. The state anticipates that at trial, the defendant will attempt to introduce testimony from Post and law enforcement regarding Post's pending child pornography charges and the discovery of the child pornography during the course of this investigation. In essence, the defendant will attempt to assert that because Post was in possession of and associated with child pornography material, he is more likely to have committed the murder. By this logic, the defendant would be using the quote-unquote shock value and heinousness associated with the subject of child pornography to project what it is ultimately a completely untenable connection between Post and the murder of Parcell. More specifically, this evidence lacks any tendency to make less probable the defendant's alleged involvement in the murder. The time frame and the physical description established by the ring cameras in conjunction with the DNA evidence provides only a question as to the identity of the killer. Post devices which contain the child pornography, including his phone, contain no communications or material pertinent to the murder investigation, nor any material that the state would present at trial. Where the defendant may attempt to offer the child pornography evidence as being construed towards some sort of motive or lack thereof, it would require the defendant to present facts which create some nexus. Jesus Christ, I need a drink, hold on. the defendant to present facts which create some nexus between the murder and the child pornography. To that end, the defendant would either have to testify or call a witness to establish the relevance of such testimony, as no evidence collected, including all electronic evidence gathered by the state, provides that any witness had knowledge of the child pornography material outside of post. Well, so they're not even saying that Christina had knowledge of it.
I mean, that doesn't even make any sense.
Why?
How would she not have knowledge of it if she's literally in the pictures and videos?
According to the opposing side. We don't know that.
Is this, but is the state here saying that she was not in the pictures and videos?
He's saying that nobody would have had access to the materials or known about the materials besides Bradley Post.
But he's charged with distributing CSAM.
He's not convicted of it.
Yeah, but he's charged with distributing.
I'm just telling you my thought process here. I don't know what to tell you.
I think they're all trash, all of them. I mean, it doesn't mean that, if he murdered her, like, that's not, he can't do that. He can't murder people, but, like, I don't know.
So, Skinny.
How did John Melo get those emailed to him?
I don't know. That's a totally separate thing. I don't understand.
Is it? Are all these things separate?
I don't know.
I don't know. I don't think. I don't know.
They have charged Bradley Post with, I believe, currently he's facing 9 counts. And then he is facing the distribution of it because according to the opposing side, he was sending it to third parties. And according to the opposing side, she's in them.
Yeah, but they would have gotten that information from the criminal investigation. Like, the information that they're putting in their stuff for the civil stuff is stuff they're getting from the criminal stuff. Like, I would assume that the civil attorneys would have access to that kind of stuff, like where we can't get it from the
Yeah.
Like, I would imagine they could, though, especially if they were representing the minor children. I find it super interesting that the sister is the one essentially being sued.
Oh, that one. I was thinking of the other sister. Boo. The opposing side alleges that Christina is seen in the videos and photos posing the girls.
I'll have to pull up the answers because for the civil, I don't know if you did, but for the civil things, for each one, there's the complaint. It's like 1 through 50 or whatever. And then in the answer, the sister goes in and answers 1 through 50. And she says, like, they either deny the claim or they admit the claim. Like, if it says that she lived at 122 Crane Break Drive or whatever, and she'd be like, we agree with this.
How about
like,
Lutina?
Yeah.
So well, Lutina and Brad Lutina and John Melo had come to a visitation arrangement, and then they Melo alleges that Lutina was taking photos of the daughter nude coming out of the shower.
But maybe that's different than what I'm thinking. I'm thinking of the daughter and the friend who are suing Post and Christina's estate, which is Lucina. Or Lutina, or whatever her name is.
Lutina, yeah. But apparently the taking photos of her coming out of the shower was not proven, and so that was dropped, and now they're still in a custody fight over this child for visitation for Lutina.
Did she say, like, other than all of this other stuff with the pictures and all that shit, like, why is the sister fighting for custody?
She just wants visitation. She wants to see her niece.
She's living in Italy.
I don't know. I don't know where she's living. According to Isabella on Reddit, they were happy living their best lives in Italy. I don't know if that's the case. When Lutina testified, she said she hadn't seen her since September, but that was still under like litigation.
Well, did they say why they took her in the middle of the night? Was it
No.
because, or are we just inferring that it's because they found all this stuff and they were like, oh my God, that's the same house?
That's what I think. I think they needed
Okay.
to take her to make sure that whether this person was involved or not, because it's the exact same time frame. The 19th, they find all that stuff on post, and she said within the first week they came and took her at 10:30 at night.
Right. What a tangled web.
Right. Okay, so the evidence is not applicable towards third-party guilt. So this is kind of what I was saying before about the SA allegations and the CSAM being if you're going to bring, you can't really bring the CSAM in if nobody knew there was CSAM until after she's murdered. It doesn't really do any good unless you can prove that somebody knew that there was CSAM to point to a third party.
Well, the people doing the CSAM. So technically, if I'm the defense attorney and I'm thinking post, if Christina was going to tell about what was happening,
right,
then that would give post motive. The problem is I'm pretty sure that the only reason that this is kept out is because post hasn't been convicted. So he's still innocent of that.
Right.
So he couldn't even really use it for impeachment, really.
So the evidence of potential third-party guilt of the murder of Purcell by post is inadmissible, pursuant to State versus Gregory. Such evidence lacks any foundation or cohesion with the facts and the circumstances of this case and only serves to cast an emotional and inflammatory suspicion at a state witness to the jury.
But let's be so for real. Like, okay, I do get that, but don't you think that the jury would want to know? Like, I personally would want to have known that the person whose credibility I'm trying to determine might have been doing this stuff. But I get that he's not been convicted, but also that's up to the state to when he goes, well, not necessarily up to the state, but in order to not have that come in, what's stopping them from dragging their feet? Knowing it can't come in if he's not been convicted.
Why did they push for a delay until he's convicted? I don't even know if he actually has a trial date set. Last I looked, there was no trial date set for him, but I don't know. I could be wrong.
There really wasn't much, I don't think, whenever I looked. Like, there wasn't really much at all.
So you think the third party would be Brad Post
to the defense?
To the defense.
Yeah, for sure. I think if they were going to bring in third party stuff, it would be Post.
Isn't that hard? Don't you think that I don't know how they would absolutely be able to do that if they confirmed his actual alibi and have him at other locations?
Well,
correct, Susie. Yeah.
So they have him going into the house
at 10:57.
Right.
Mm-hmm.
And like, she wasn't dead for a long time, obviously, because we know she went out of the house.
She had to have died between 9:15 and 9:27 a.m.
And I guess the thinking is that Post was clean. Like, how do they know that where was Post in that time?
Home or somewhere else calling her. So they have him other places calling her.
His phone was left at home?
I think she's.
Or are you talking about Zach?
I think she's talking about Hughes, which we don't think his phone was actually left at home. We think it was turned off or put in airplane mode, because he would have had to have had his phone because he plugs it in at 7:45 a.m. and he would not have been able to make it to the neighborhood in time to be if you go with what the old nosy neighbor says, where she saw somebody at
I don't believe her.
8:07 in the morning. No, 8:15 in the morning. See, I guess this is my struggle because the victim was a disgusting monster and it would totally sway the jury, but I'm okay with that. She was a horrible and abusive human being. I guess my struggle with that is she's not proven to be any of those things.
Well, for me, victimology is important, right? Like, do we agree on that?
Oh, yeah, absolutely.
So, like, if she was a prostitute at some point, like, that could be relevant. So, it's not necessarily like, I'm not sure that the jury should be swayed about, like, whether they think she deserved to die or not. But I think when you're trying to determine, like, if a person could have done something, knowing about the, oh, that is like the old, like, I'm so tired of hearing that. It's absolutely fucking ridiculous. The whole criminals often leave their phones at home or turn them off when doing crimes. And it's like, okay, so if your phone shows up, you're guilty. And if your phone doesn't show up, you're guilty because you just turned it off before you went. It's a lose-lose. Mm. Nobody alleged that the photos were photoshopped yet, but who knows?
Right.
I
We
wonder if
we
they'll
don't know any.
televise that.
I
Probably
think
not.
that's my struggle, and like you said earlier, because none of these people are convicted of anything. How do you automatically say that they did this unless if you brought all of it in? This is my point again. I'm going to go back to it. The same thing. If you go with the essay allegations, you give Melo and Hughes motive. Which, as a defense attorney, do you want to do that?
I mean,
Because
I don't know, but I'm here to tell you that the way I feel about it is that I understand that he's not been convicted of it. However, just like with Stephen Stern, I don't know if he killed Madeline Soto. I don't. But
I think he did.
I'm not going to sit here and, like, suggest there's somebody else in pictures. You know what I mean?
Right.
Or that somebody photoshopped them. Or, like, I don't know. We're talking about like 15,000 things for this particular case. And so I just, like, the odds are he probably did it. You know what I mean?
Right.
So, I mean, I know people think that he killed her, and, like, yeah, he might have, but he also might have just got rid of her too. I mean, I don't know. I saw a lot of stuff, and I didn't really see much of, like, that in particular, the death stuff. It was a lot of the other stuff.
Yeah, but they're gonna think he did it because of the other stuff. And there's other stuff that they imply that we won't know till court. But all right, let me go back to this. Let me see. So the evidence is not towards third party. Evidence offered by a defendant as to the commission of the crime by another must be limited to facts inconsistent with his guilt and facts that raise a reasonable inference or presumption as to his innocence. Evidence which can have no other effect to case a bare suspicion upon another or to raise a conjectural inference that the crime was committed by another is not admissible. The Supreme Court goes on to detail that before such testimony can be received, there must be such proof of a connection with it. Such a train of facts or circumstances as tends clearly to point out such other person as the guilty party. Remote acts, disconnected and outside the crime itself, cannot be separately proved for such a purpose.
So listen, if bringing the CSAM stuff in was going to provide the state motive.
No, not the CSAM.
Well, they were looking to, and they succeeded in excluding the CSAM.
Right, which I think they should have, because the CSAM isn't known until after the murder. So how can the CSAM be anything to do with the murder if nobody knows it's happening?
Because the CSAM is of the SA.
So, right, it's still not the same thing. The SA is still separate.
Well, that's kind of unfair if you consider. unless it was just post, but like Christina is dead.
Correct.
So like that would be like saying the kid is saying that she'd been through A, B, and C, right? But because Christina's dead, no one will ever know because she can't be convicted of it. You know what I mean? It can't ever be brought up. It can't be proven because she's not alive. That doesn't mean it didn't happen. And your evidence of that would be the CSAM.
True, but you don't have that before the murder.
I would also say to the state, okay, you want it excluded. It's not been proven, but like, are you routinely like arresting people? You think you can't prove that they've done something?
Susie Q, no, because you're talking about the same person.
Oh, and he's got like a bajillion of those charges, so that's got to come in. They'll probably. Do you think they're going to do it separate?
I don't think so. I think they would do it all together, but I haven't followed the legal stuff on that case for a while now, so I don't know. But no, I think it's different because the person committing the CSAM is the person on trial for the murder. This is different.
Prior bad accident.
Now you have the victim who's accused of being a perpetrator, but how does the CSAM fit into the trial? If nobody knows about the CSAM when the murder occurs, what does it have to do with the murder?
So the taking of the CSAM and let's say the distribution of it are different. The one's just like a record of you committing SA. The other is sending that record to others. So I just feel like it's not that far off to say I don't know. I don't know because I'm still really confused about how this was an accusation for multiple years. There was this 15,000 things of CSAM, and we have this lady get on the stand talking about how she was abused by Melo and couldn't find any evidence, but like there was a shitload of CSAM. So I just don't know how she didn't find it.
Because it was on Bradley Post's device and she doesn't have them, or she's not going through her phone. I mean, according to her, she says that the child is like flourishing.
I mean,
but then the child testifies and says, at the custody hearing that she's the best thing that ever happened to her was when her dad took her to Italy.
Well, yeah, away from the things she had been making accusations on for years.
Or because it's 3 years or 2 years later and there is no mom and you only have dad to live with.
Oh, you mean like because mom was dead, so she doesn't want to go to foster care, so she's going to say that she's happy with her dad, is what you're saying.
Right.
I don't know. I think regardless, I will be stunned if they vote not guilty. I mean, I will be absolutely stunned just because of the DNA.
Yeah, I think that they still have to bring somebody on. Like I said earlier, I think they have to bring somebody to show the cross-contamination and how often it happens, and then it does happen.
Yeah, even then, I
Okay, so as summarized, the state alleges this murder to have taken place between 9:07 and 9:30 on October 13th, which is substantiated by the video footage the state intends to introduce at trial. The same video evidence records Post's vehicle at the home at 11:05, an hour and a half after the murder takes place. The state anticipates that at the outset of trial, in opening statements or in the course of Post testimony, that the defendant will attempt to introduce statements, testimonial evidence, or physical evidence as related to the child pornography in Post. At the point the mere mention of child pornography is introduced, there will be no way to unring the bell, regardless of any instruction by a trial judge. More specifically, there will be no way at this early stage in the trial for the defendant to establish such proof of a connection of the child pornography with the murder itself, or the underlying harassment and conspiracy for that matter, to clearly point out the Post as the guilty party. The introduction of this testimony by the defendant runs in plain contravention of the Gregory standard and its progeny. Specific to murder, our courts have upheld and applied Gregory in a number of instances. Okay, so they're just going to go through all the legals part. I'm not going to read all that. Witnesses may be impeached. All right, I'm not going to read that either. All right, well, I want to show, I'm going to do this next because I want to show the motions hearing that actually happened the day of trial, the day the trial started, that we didn't actually watch. I don't know if you remember that. So this is about the CSAM stuff.
This trial that we're in now. But please make sure that you have that. And again, I welcome you to our courtroom. I do want to just say a couple things, though. And I think that you all are probably fully aware of this, and this is really for your protection. But you are not to use the name of a minor in any reporting. And also, I have gotten a couple questions, recurring questions about my order. There is going to be a 30-minute delay. And again, I just ask that you abide by that order.
That's just news people stuff.
Wanted to raise that with you. Reporting on anything for a 30-minute delay. No objections. Yeah. And I appreciate you doing that. That was on my checklist of whether or not y'all had any objections
for a 30-minute delay.
Selection of the jury. Thank you, Mr. Mormon. And the state does not have any objection either. Okay. Selection of the jury. So no motions pertaining to.
I didn't know that, and I want to know what happened in that second part of day 2 or 1, whichever one it was.
Took it down.
Yeah, I wonder why.
I don't know. So this was actually supposed to go to trial like over a month previous, and they didn't have enough jurors show up for jury duty.
So they initially filed a motion in limine later.
Because the jurors didn't show up for jury duty. Okay, so this is about the motion in limine that we just read.
The state filed an amended motion in limine, and I think that we will hear that one first.
Yes, Your Honor. The state filed a motion for a gag order specifically regarding the accusations that were alleged by the defense counsel against the victim in this case, Christina Parcell. And it was in conjunction with our motion to exclude evidence relating to the case against Brad Post, who was going to be a witness in this case. Your Honor's familiar with. He's been charged by the state of South Carolina, being prosecuted by the Attorney General's office for sexual exploitation of a minor. That case occurred about 2 weeks. Those charges were brought against Brad Post about 2 weeks after the murder of Christina Parcell, and about the same time that the defendant in this case was charged. And so we filed a motion for a gag order for the purpose of keeping those statements out of the record and out of the press and from reporting on it, because the state felt it was prejudicial. And it was in conjunction with our motion to exclude evidence of child pornography that is allegedly found on Brad Post. And I say allegedly because Brad Post has not been convicted. He's been charged with sexploitation of a minor first and third, and I believe buggery, based on lots of videos and photographs that were located on his phone and thumb drives and computers. He just happened to be the fiance of Christina Parcell.
It is interesting because the state is the one who's also pressing the charges against Bradley Post. So they obviously believe that he did do it, right? And then they're saying, well,
that's what I'm saying. That's what I'm saying. They're like, he's not been convicted of that. And it's like, okay, so do you think you can't convict him of that? Which is not how they think.
No, not at all.
Like, he's guilty. They just don't want him to be guilty before this trial happens.
Right. That's probably why there's no trial date.
And so we've asked this judge, Your Honor, one, to keep the defense from putting those in their motions. Put those things in their motions so that information, which has been unsubstantiated at this point in the trial, this point in our procedure, and if it was necessary for a filing, to redact it so we could keep it out of the hands of the press and a potential jury. In addition, the state was attempting to comply with the Victims' Rights Act as well, which a victim, in this case Christina Parcell, has a right not to be shamed and ridiculed in the case against the defendant who's allegedly committed this murder. So that's sort of gone on, and that we filed that back in October, Your Honor. And at this point, the state withdraws that motion for a gag order, as we've now picked a jury, and so it's basically moot at this particular time. And then we'd like to move on to hear the exclusion of the child pornography evidence or anything related to the Brad Post case in there for the purposes of this trial. I'd like Your Honor to hear that. I know we've been and I know you had something to say about the gag order.
Yeah, and just for the record, I am, you've withdrawn it now, but I would be denying that. And just for the record, I have reviewed Nebraska Press Association versus Stewart, in Ray Murphy Brown, LLC, State, Rec Co versus State, State versus Price, And again, I would be denying that motion if it was not withdrawn. I also would note the case of ex parte, capital U drive it, in which it stated, quote, judicial proceedings and court records are presumptively open to the public under the law and First Amendment of the U.S. Constitution and the state constitution, Article 1, Section 9. I do want to note for the record that at no time has there been any order by any circuit court, any judge here that has ever sealed any of the filings that have been made. It's my understanding for the record that the state specifically asked the clerk's office to hold certain filings. And so I just want to make sure that the record's clear and that the clerk will be instructed to make public any filings other than, I mean, I guess the gag order does not need to be filed. Okay. All right. We will move on with your motion, which is your motion in limine, amended motion in limine.
Yes, Your Honor. Yes.
When you're ready to proceed.
Thank you, Your Honor. Yes. So the state filed a motion, an amended motion to exclude any reference to any evidence of the child pornography. I say the alleged child pornography. Again, has not been substantiated in any court, as Brad Post has pled not guilty to those cases, to his particular case. All of the items were found on devices in his possession or under his control. And so our first argument, Your Honor, was that in this particular case, in the case of who killed Christina Parcell, Zach Hughes has been charged with that crime. That particular crime that may or may not have been committed by Brad Post has absolutely no relevance to this particular case. And so that's of course our first argument of that. And we highlighted in our motion, Your Honor, the highly prejudicial effect of putting in the fact that child pornography may have been on some of his devices there. And I cite State v. Cooper as well. Evidence which can have no other effect to cast a bare suspicion upon another or raise a conjectural inference that the crime was committed by another is not admissible. But not only is there conjecture, Your Honor, there is absolutely zero relevance to any and all child pornography to this murder case, and there's no nexus, and the defense cannot provide a nexus at this stage in the process. And so, Your Honor, we would ask you to exclude any and all reference to child pornography, which goes to also Brad Post's testimony as well. We've also asked this court to limit the testimony of Brad Post. And for the record, Your Honor, his attorneys asserted a blanket Fifth Amendment protection on his behalf in relation to that. It's my understanding State v. Lawrence is the main case on that as well. And the key to that.
So if they do start, he's essentially saying if they start asking him about this stuff, he's going to plead the fifth, and you're not going to get any answers anyway. And all you're going to do is prejudice the jury against the victim.
Yeah, I'm sure that's not an accident.
No.
Is that he's not an inculpatory witness. He's at the bottom of the chain when it comes to evidence against Zach Hughes. His testimony will be, I've never even met Zach Hughes. I don't know Zach Hughes or anybody that from the public. And so Zach Hughes, the name of Zach Hughes will not come out of his mouth other than I don't know who he is. So by allowing impeachment evidence, pursuant to Rule 608, 609, diving into his current charges, because they're not convictions yet, of a non-inculpatory witness is what State v. Lawrence and others stand for. And so when you have a non-inculpatory witness, your ability to go into their potential impeachment sort of diminishes and it lessens as you go forward. All the other cases that we cited, Your Honor, are folks who were eyewitnesses to crime or they were in the car before a murder happened. In this case, Brad Post is merely just going to talk about how he arrived at her house at around 11 o'clock on the 13th and found her deceased body inside her house, and the house where she lived with her sister and her daughter. So we would ask this court to restrict that any mention of that evidence on those grounds in relation to Brad Post, as well as the impeachment. We would ask this court to limit the impeachment or the conversation about his pending charges to have you been charged with a crime would be the extent you can go into his pending crime now that he's defending against. Otherwise, Your Honor, at the end of the day, going into his particular crime would serve this jury absolutely no purpose as to whether Zach Hughes committed this crime or not. Again, at this stage in the proceedings. So we would ask Your Honor that. And we would also ask you to restrict the defense's ability to cross-examine him on that particular area. As, again, it's not relevant and it's extremely prejudicial. And I remind Your Honor, if this jury hears about any child pornography related to the victim in this particular case, you cannot unring that bell. You cannot unring that bell. And it is highly, highly prejudicial to the victim in this case. It is a violation of the Victims' Rights Act unless there is a mechanism and relevance and a path to that evidence at some point in time. And Your Honor, the state believes there is no path to that evidence. There's certainly no path to that evidence.
He looks like, motherfucker, you really not gonna let me mention this?
Right.
Any evidence.
So Travis, this is the pretrial here. This is the pretrial hearing. That's actually the day the trial starts. So it's the morning the trial actually. They called Brad Post to the stand, and the judge does grant the state's motion to exclude. Yes.
And so we certainly would ask Your Honor to restrict that. And if you do restrict all of those things, we would ask that we don't need an in-camera proffer of Brad Post. As far as the state's questions, we have gone over those. I've submitted those to the court. I've submitted those to defense. Brad Post has responded to those. He did not assert his Fifth Amendment right on any of the questions that the state begins to ask. And so by allowing the defense counsel to get up here and ask him questions they know he's going to take the fifth on, or in that square box of child pornography related questions, it would really just allow them gratuitous information into the world that has no bearing on this particular case. And so we would ask Your Honor there's no reason to have an in-camera hearing and restrict their cross-examination and of course our direct examination to non-child pornography related testimony regarding the defendant and the victim in this case.
And I want to hear the defense.
Not at this moment.
Your Honor, may it please the court. First, a timeline I think would be useful. The state moved to exclude this evidence in September of 2024. In November, we had a bond hearing for our client. After the bond hearing, the state instituted the motion for gag order, and sometime around there amended the motion in limine. So, Your Honor, I would argue that that timeline, I don't think necessarily they were in conjunction with each other. Your Honor, this I just have to deal with this from the get-go. The state has told Your Honor once again that these allegations related to the child pornography are, quote, wholly unsubstantiated. This is a refrain that we've seen repeatedly in the pleadings from the state. We have made it very clear in our pleadings in response to theirs that we in no way want to discuss this topic irresponsibly, discuss it gratuitously, but over and over again, when the state alleges that it's wholly unsubstantiated, we just have to address that, Your Honor. It is highly substantiated. We have evidence to show that. And as an officer of the court, I represent that in pleadings. Mr. Moyer has represented that in pleadings. And that evidence exists, and we're prepared to introduce that evidence. But I want to set that straight. That evidence exists. We're prepared to show it and prove it. As it relates to what the ask is in the motion, extraordinary relief they are seeking. 16,000 or more images of child pornography. We have photographs. We have videos. They want Your Honor, without having seen any of it, without having it introduced at trial, any exhibits whatsoever, to categorically exclude 16,000 or more pieces of evidence that we may or may not seek to introduce. So they want Your Honor, again, to, from the bench, without any evidence introduced of any kind, without opening statements, with nothing, they want Your Honor to exclude that evidence.
Mr. Morgan, assuming that is the case, their point still is, I don't care if you have 45,000 videos, it's still not relevant, is what you're saying, if I understand correctly. So
and relevant being makes a fact and issue more probable than not. It is highly relevant. We've also, there are cases that discuss relevance in the context of Rule 402. Relevance relates to evidence that helps the jury get at the truth. Right? And I would actually cite State versus Sweat for that proposition, and I can give you a cite on that. But relevance is evidence that assists the trier of fact, in this case, the jury, to get at the heart of the matter, to get at the truth of the case. Right? And the truth of the case, the bases for the relevance in this case are enormous and will become much more clear after the trial starts. And that's one of the reasons why Your Honor should, at a minimum, decline to rule on this issue until the trial starts and Your Honor can see some of the evidence and what the cross-examinations are. But Your Honor, to again, in a vacuum, to exclude this evidence before Your Honor's had a chance to review it, before it's even offered evidence, I'm not even sure how you do the 403 analysis, right? Because it's such a fact-intensive analysis. The other thing is when the state argues that it talks about prejudicial evidence, absolutely. Every piece of evidence the state seeks to offer against Mr. Hughes, they believe is prejudicial to Mr. Hughes. Every piece of evidence, should we decide to do that, we offer is going to be prejudicial to the state. But it's not unfairly prejudicial. This evidence is not unfairly prejudicial, Your Honor, because this evidence came to pass based on, in no small part, the actions instituted by Brad Post, who was engaged in this illegal conduct with Christina Parcell. So, Your Honor, it's highly relevant. Your Honor, at this time, there was a discussion about the impeachment and the nature of the charges. Oh, I also want to clean up one fact, and then I'm going to turn it over to Mr. Moyer. The state indicated that in the timeline that Ms. Parcell passed, and then a couple weeks later, Mr. Post was charged with violations of South Carolina law. The timeline is this, that Ms. Parcell passed on October the 13th, that there was one warrant for sexual exploitation of a minor, 3rd degree, obtained by the Greenville County Sheriff's Office on October the 19th. So 6 days. 6 days after law enforcement obtained an arrest warrant for Mr. Post. And they continually obtained warrants after October the 19th, culminating, I believe, on November the 23rd, wherein they obtained an arrest warrant for Mr. Post for criminal sexual conduct with a minor in the 3rd degree. But I just want Your Honor to be aware of the fact that 6 days afterwards, the Greenville County Sheriff's Office obtained a warrant for Brad Post. Now I would defer to Mr. Moyer to talk about cross-examination related to Mr. Post's pending charges and applicable sentences, potential sentences.
May it please the court, Your Honor. So there are really two issues that are associated with this. Is one, should we have?
So that's a good question, Skinny. So this is kind of what Sleuthy was talking about. That's probably really loud because I have the speaker really loud because the court's really quiet. So I'm going to try to not be so loud. But it's a good question because I think, like what Sleuthy was saying, is they want to say that Brad Post did it because of the CSAM. And so it's relevant because their third party is Brad Post. And he knew about the CSAM, and so he kills her because of it.
Have an in-camera hearing for Mr. Post, and the second is, what can we ask Mr. Post about his pending charges? So beginning with that first issue, I think we clearly need to have the hearing, Your Honor. The state expressed concern that we don't want Mr. Post just being asked a lot of questions that he's going to plead fifth to. Well, that's exactly why we need to do this outside the presence of the jury, so we know what he's going to plead fifth to and what he's not. So we're not just stopping every few questions, having to send the jury out and then hash it over. So we're prepared to ask him the questions. We're prepared to hear what his answers are, and if he's pleading the fifth, and if he's doing so properly, then we can let that lie. But Your Honor needs to be able to vet him to make sure that he's not pleading the fifth irresponsibly. That is a question that he should answer. Then he needs to answer it. So we would ask that we have that hearing tomorrow morning. We think the hearing should last 30 minutes or so. So I think that would be a wise use of the court's time and would save a lot of problems throughout the trial. The second issue, Your Honor, is whether or not the the defense is allowed to cross-examine Mr. Post about his pending charges and about the penalties. And
Janet, it would be because, like, the theory behind it would be that she was going to either stop or because they were going to break up, or somehow she was going to end his ability to get the CSAM, and so he killed her.
There's still that weird question about the ring, and
Right.
it could have been she was going to tell on him.
If you want to just give you a little background, Bradley Post faces 9 different charges. So he has one charge of criminal sexual conduct with a minor third degree. That charge is violent. It carries up to 15 years in prison, and it carries automatic sex offender registry. He has 5 counts of sexual exploitation of a minor first degree. Those charges are violent. They carry sentences that range from minimum of 3 years with no parole to 20 years, and sex offender registry is discretionary. He has 2 counts of sexual exploitation of a minor third degree. Those carry up to 10 years in prison and discretionary sex offender registry. And then he has a charge of buggery that carries prison for up to that carries a 5-year straight prison sentence with mandatory sex offender registry. Now, Your Honor, the law in South Carolina is crystal clear that the defendant's Sixth Amendment rights are violated if he is not allowed to question a state's witness about pending charges and penalties. I'm not aware of a single case in South Carolina where the defense was prohibited from cross-examining a state's witness, and on appellate review, it was not ruled to be error. And that goes not only to naming the charges, but to bringing out the penalties. And I'll go over 4 cases very quickly in a minute. But before I do, I think what is especially telling on this point is the fact that the case that the state uses, State v. Smith, is a case in which the Supreme Court ruled that it was error for the defendant not to be able to cross-examine a witness about the charge that was pending against him.
Oh, goodness. I don't know if I want to. So buggery in the state of South Carolina is it's kind of twofold. It's any type of anal on a human. It also has to do with animals, bestiality,
Which is a complaint we've seen here.
right? It's the buggery in this instance goes, from our understanding, goes to the animals. But I also found it really weird that you can't actually have anal sex in South Carolina.
What?
Yeah.
How do they know if you're having anal sex in South Carolina?
I mean, later this down, you're gonna blow everybody's ear.
I mean, I just want to know, like, are they testing people? Like, how
I
are
don't
they?
know. I was trying to look into it. And I'm like, this is craziness. Like, because I was like, does it have to be like non-consensual makes it buggery? And it's like, no, all forms of it are illegal, I guess. Apparently, I don't know. I didn't go that far down that rabbit hole because, like I said, we were told that this has to do with the animal side. But I was like, that can't be real, right? Like, how do you like a grown person that wants to
Can't choose to have anal sex? That makes no sense. And who the
a lot
fuck are they?
laws. Yeah.
Well, yeah, but that is when you say that, and it makes me literally sick to even think about. But when you say that, I think that it's like non-consensual. Like, obviously, that should be illegal. But
right. But no, when I looked into it, it wasn't. And I could be wrong. Maybe I'm misinterpreting, but that when I was looking at it, they were saying no, it's consensual. You can't do it. It's dirty. It's dirty stuff.
South Carolina.
This is a rabbit anal hole. It really is. It
This
really
like literally doesn't apply to me in any way, but I'm just super curious to know. Like, I don't care what people are doing in private, as long as they're not hurting people or hurting children. But like,
sodomy used to be illegal everywhere. I don't know the history of sodomy, so
I'm
like
so confused. I thought that was something different.
I thought it was like unconsensual. Like when somebody says
Yeah,
like that's what I would think. It's unconsensual.
or
But apparently
objects
no.
or whatever.
No. Yeah.
What?
And Blind Hog says that it also includes oral, which I did not find. I did not get that in the rabbit. I left that rabbit hole very quickly.
What?
I know this is like people are like, "What the hell are you guys talking about?" But like, this is.
It says. So South Carolina Code of Laws, Crimes and Offenses, Chapter 15, Offenses Against Morality and Decency, and then it says buggery. Whoever shall commit the abominable crime of buggery, whether with mankind or with beast, shall, on conviction, be guilty of felony and shall be imprisoned in the penitentiary for 5 years, or shall pay a fine of not less than $500 or both at the discretion of the court.
Yes.
That's also not very specific. It just says, it doesn't explain what buggery is. It just says if you do buggery.
Yeah, you can't do it. You can't do that kind of stuff.
The buggery law has been there since 1712.
Nobody should ever look at my Google history, Law Junkie, like ever. I really hope, like, if anything ever happened to me, that the cops would go, okay, this is the case she was looking at for online purposes, and then this is why my Google history matches that. Like, otherwise, they're
going to be looking at unsolved cases.
If my discovery and my Google searches comes out in discovery, it's going to be really bad. I'm just going to, fair warning, it's going to be really bad. Yes, Skinny. Yes, essentially. And thank you for asking about the buggery, because it's an interesting one. Oh gosh.
In that case, they just mentioned that he had pending charges. The defense was not allowed to go into what the exact charges were, and the Supreme Court said that was error. Now, in that particular case, they found it harmless error, but it was error nonetheless. And there are multiple. Yes, sir. That's quite right.
In that case, the witness, was it someone who was offended?
Your Honor, in that case, no, it was not. It was someone who testified. He was a victim in the robbery case. He testified about identification of the robber, who was the defendant in that case. That person had pending carjacking charges. And actually, in that case, what happened is the state actually dismissed that charge that morning in an attempt to try to keep the defendant from being able to ask about it. This is actually a PCR case. The Supreme Court ruled that it was deficient of the defense attorney.
I hate that I have to keep turning this down. Okay, so he said Google Lawrence v. Texas. It says Lawrence v. Texas was a 2003 Supreme Court case that ruled unconstitutional a Texas law criminalizing consensual sexual activity between two adults of the same sex. The ruling established that the Constitution protects the right to privacy and liberty, and that the government cannot criminalize private sexual behavior. The case involved two men, John Lawrence and Tyrone Garner, who were arrested and convicted. The Texas law criminalized homosexual sex, even in the privacy of one's home.
The audacity.
That is just fucking crazy. It is.
That really is crazy. Like I said, if it's not hurting someone, I don't know why it would be any of my business.
It's a bunch of anti-gay laws.
That's
scary. And that a lot of states still have an effect. That is bullshit.
So you're telling me okay, hey, I'm going to throw you for a loop now. What if you are by yourself
Oh, I don't think you
and
can
you're
do that.
just like doing butt sex like with whatever.
I don't think you can do that, Sleuthy.
What?
I don't know. I don't think so.
So even if
We're gonna
somebody else is not involved, that's crazy. That is
somebody needs to actually like
insanity.
create a channel that's just based on like all these weird old laws that still exist in these states and go through them, because like this could be like an entire live of a rabbit hole to go down.
I've heard of some where I'm like it'll say like laws that it was like an article. There's like articles that'll be like laws that you won't believe are illegal in certain states or whatever. And I read them and I'm just like, this has to be illegal. This can't be true. So, and then I just brush it off because it's just so ridiculous. So you mean to tell me if they find out somehow, which I don't even know how they would find out. Let's say it's the shape of a penis.
Well, I think that it has to. I mean, if
Or
it's
a
a
butt plug.
if
You're
it's
telling
oh
me.
my gosh, you guys.
I have to understand how far this goes.
Well, I think that's why I said this could be a whole rabbit hole of a live.
That is bullshit.
All right, let's keep playing this. Hold on, let me.
For not pressing that issue and striving to have that charge named. Again, in that particular case, it was found to be harmless. There are a few cases where the courts have found it harmless error. There are many where the courts have overturned convictions, murder convictions. And so basically what you're being asked, it appears, Your Honor, is to just go along with the erroneous ruling, and let's just hope that the Court of Appeals finds it harmless. So so that's State v. Smith. Now there are other cases, Smalls v. State. That is a case where the Supreme Court overturned the conviction because the defense attorney was found deficient for not attempting to impeach the witness with a charge and potential penalty. There's a State v. Gilliam. There, it's a burglary case. There was a co-defendant in that case, and the defendant was prohibited from questioning the co-defendant about the penalty for burglary first degree, which was 15 years to life. And the Court of Appeals found that to be error and overturned that conviction. State v. Mizell. In that case, the defendant was denied permission to question a witness about pending charges, and was denied being allowed to ask about potential sentences, and the court overturned that conviction as a violation of the Sixth Amendment. And then State v. Sims, Your Honor. In that case, there was a state's witness testified, had numerous pending charges unrelated to the murder case that was before the court. He had drug charges, grand larceny, robbery charges, and the court ruled that the specific charges could the trial court said that the specific charges could not be mentioned, only that he had pending charges, and that was found to be error. So, Your Honor, in this case, I think the law in South Carolina is crystal clear that when a state's witness is cross-examined and he has pending charges, he can be asked about what those charges are and what the penalties are. And so, Your Honor, we would seek to do that.
Does it matter to you that it's the AG's office as opposed to the solicitor?
It's the same party, Your Honor. It's all the state. So that does not make a distinction. It's in the 13th Circuit. It just happens that and I don't think it matters. I think the charges could be in Richland County. It could be in North Carolina. What matters is there are pending charges. And the implication is that somebody testifying with pending charges, even if they don't have a deal, in fact, it's even more relevant when they don't have a deal, because the courts have ruled that that person is going to be going out of his or her way to try to ingratiate himself to the prosecution so that down the road.
Oh, okay. That's a good argument.
I cooperated with the state. You need to take that into consideration. I testified.
Yeah. I mean, that's a good argument.
What do you think is good?
It's I guess I hadn't even been thinking about it that way, in the sense that it would be even more important, I guess, to be able to show the jury that Post has, considering his charges are still pending, with the same state that he's testifying for, that it would be important to let the jury know that he might, whether he's been offered any type of deal or anything, that he still might be thinking, essentially, that if he does good in his testimony for the state, that they might be more lenient on him for his pending charges.
I think they ask him that, do they not?
I don't know. I also vaguely remember, and I might have made this up, but I thought he said something about, maybe they asked if he had pending charges, and he said something to the effect of like, for all the things found on the devices, or something like that. I'll have to go back and look, but that is a good point in terms of like cross-examination, like being able to show the jury that he might have a reason to
I don't
testify
think he has.
favorably.
I don't think he has a plea deal. I think that was part of it. That's why I remember. That's why I'm thinking they asked him. I don't know if I read that he wasn't offered a plea deal, but I don't think there's any deal in the works for him for testifying. I just don't remember where I heard that now.
Right, but he's saying what this attorney is saying is even if there is no plea deal in the works, that doesn't mean that he's not thinking that if he testifies favorably for the prosecution, who is also prosecuting him, that they might be more lenient on him after. Or be
But
able to use
I think
that later.
I don't think that would work though, because if it's talking about a plea deal, then he's talking about admitting guilt on a crime that he's not admitting guilt on.
Well, yeah, if it's a plea deal, but well, they haven't even like decided to go to trial. There's barely anything in the record that I can see.
Right.
I don't know. I'm just thinking if he were thinking, I'm going to do this, and then if Zach gets convicted, come back to the prosecutor and say, I basically helped you get that conviction, blah, 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 blah. It might not work, but that doesn't mean that he's not thinking it when he's testifying. Like, should they be able to show that someone might have ulterior motives in their testimony? One could argue that the possibility of them being blamed for the murder could be a reason why they would want to testify against the murderer.
True.
I don't know. I thought that was a good argument. And it almost seems like they're arguing two different things. Like, he's arguing that they should be able to bring that in for like impeachment and stuff like that. And then the state's arguing like that shouldn't get to be brought in at all whatsoever. Because I don't know. It's weird. I mean, we obviously already know the outcome of this.
Right. Okay.
And I want to say the judge says that because he's not been convicted, but we'll find out here in a minute.
Whether there's a deal or not, whether it's in 13th Circuit or not, whether it's being prosecuted by Mr. Wilkins' office or not, they're pending charges and they need to be asked about. So that's your argument for 608C. Yes, sir. Not this time. Thank you. Yes, Your Honor. Briefly, I'm going to have Mr. Hoforth respond to the Smith case, but Your Honor, this is a simple issue. The defense cannot establish any relevance whatsoever to the case against Brad Post. That, number one, I can't give Brad Post any deals because I'm not prosecuting him. So it's very relevant, that issue. But what is on Brad Post's phone has nothing to do with this case. And they still can't establish a nexus to it. They can't establish any relevance to any of that. And until they can do that, there's no reason this jury needs to hear anything about what's going on with Brad Post and his separate crime. Because, Your Honor, whether they like it or not, Brad Post is not on trial here. Zach Hughes is on trial here. And so the fact that Brad Post may have child pornography on his phone really has no place in this courtroom here today. Mr. Hofer is going to respond to the State v. Smith, and I think it's related to the fact that Mr. Post is not an inculpatory witness, and that's what they keep not wanting to talk about. All the cases that Mr. Moore is talking about have an eyewitness to a crime, somebody that's very inculpatory to the defendant. Mr. Post is not going to inculpate Mr. Hughes one iota, and therefore your ability to go down a rabbit hole into some pending charges that he's not pled guilty to is limited in that respect.
Thank you, Your Honor. I'll be as brief as possible, but it's important to start with the foundation here where we're talking about the testimony of Brad Post specifically and the nuance with this case with the backdrop of South Carolina law. I cited Smith and Mitchell in the state's brief because they are the most pointed to the circumstances related to this case, but really the circumstances related to Brad Post's testimony go a step further to warrant the exclusion of such cross-examination as to the sentencing he might potentially be facing, or even the naming of the specific charges. I'll note that the two cases that Mr. Moorman went into great detail on, Gilliam and Mizell, both of those instances are where the witness is charged with the same crimes that the defendant is facing. So obviously that would be probative upon cross-examination to even if there's not a deal in place to pry as to the potential bias of that specific witness. But starting with the your ability to tailor this to the specifics of the case, and that comes from the United States versus, I'm going to mispronounce it, but Fredick, F-R-E-I, right? Fredick. It really needs to be a case-by-case analysis. And in Smith and Mitchell, those two witnesses were eyewitnesses, inculpatory witnesses to the crime itself, and then charged with collateral, offenses. In both of those cases, the Supreme Court, or the court, held that the only essential information that was excluded from cross-examination was defense counsel's latitude in being able to name the specific charges with which that witness was charged with. Not to get into sentencing, not to get into what they were potentially facing, only what the specific charges were. Now, this does also go in conjunction, like most all things in this case, going back to the state's motion and why we filed it with such advance to exclude such mention of child pornography in this case, because we are necessarily eliciting on direct examination that Mr. Post is charged with a crime. Yes, that he is currently in jail. Yes. But as soon as the cross-examination comes out and the question is asked, well, you're charged with criminal sexual exploitation of a minor, that opens Pandora's box in the present case. And of course, looking back to exactly what he's testifying to, he doesn't know who the defendant is. He did not know at the time of the crime, on October 13th, 2021, who the defendant is. He is testifying necessarily because he found the body of Christina Parcell, because he received envelopes going toward the harassment charge of Zachary Hughes. And mind you, he didn't even know who sent those harassment envelopes. And he's testifying to the blanket, to the bare minimum that he was in a relationship with Christina Parcell to explain why he would show up at the house on the morning of the 13th. This is not an individual who says this is Zachary Hughes who committed the murder, who provides any evidence towards attributing Zachary Hughes committing this murder. So it's completely within your discretion to curtail the cross-examination, to not elicit the charges, but certainly not the sentencing that he faces in opening that door.
Your Honor, I refer you to 610B. It says cross-examine on any matter relevant to the issue in the case, including credibility. So even the rule contemplates relevancy.
May it please the court. And the relevancy, Your Honor, is bias. And that is a hugely relevant point in any cross-examination. I'd like to read just a little bit from State v. Gilliam. It says, the fact the witness has yet to reach a plea bargain or been found guilty should not prevent the admission of such evidence. The lack of a negotiated plea, if anything, creates a situation where the witness is more likely to engage in biased testimony in order to obtain a future recommendation for leniency. Accordingly, we conclude the Court of Appeals erred in holding the trial judge properly excluded testimony concerning Steele's potential sentence if convicted of the same crime as defendant. Included in the Confrontation Clause protection is the right to cross-examine any state's witness as to possible sentence faced when there exists a substantial possibility the witness would give biased testimony in an effort to have the solicitor highlight a future court how the witness cooperated. So there's no distinction about whether the person is testifying about something that's inculpatory or not, about what the nature of what the person is testifying is about. And if the state can find any case where it makes that distinction, we would love to see it, because it's not there. And because oftentimes we don't know when a person testifies, sometimes it does not become clear how significant that testimony is or what implications are of that testimony until down the road we start hearing from other witnesses. It just comes down to the fact that if it's a bright line rule, if he is pending charges and he testifies for the state, then it can be asked about. And just one other point, Your Honor.
The witness, it was Page in State versus Gilliam?
Let me look at my notes, Your Honor.
Was it a co-defendant? Was it somehow tied in with the crime?
I think Page was a co-defendant in that case.
So what you're, and just with I think with the Gillian case you had, it was a murder case. He was tried for murder. The murder burglaries. Well, the murder weapon was obtained in a burglary previously that Page, the cooperating witness, participated in. But you know, I would just reiterate what the import of the argument is, Judge. If the witness is really testifying about something that hurts the defendant, then he can be cross-examined on this. But if it's really not that big of a deal, it's not too inculpatory, then his credibility is not a big deal. There's just not distinctions out there on that. If they put this witness on the stand, this witness has a motivation to curry favor, to get help on his pending charges, then that's open season. That's what the Confrontation Clause allows. And what Mr. Moyer has said is so true, that case after case after case, trial courts have been reversed when they've sought to limit cross-examination on pending charges and on possible sentences. There's no distinction that we've been able to find in that, period.
You're going to have a witness up here just asserting fifth over and over and over. And of course, that gets to why you feel like you need to have the in-camera hearing. On the Fifth Amendment and the Sixth Amendment.
Okay, hold on. Let me turn my mic down. So this guy is living with the murder victim, comes home and discovers the body. Later is charged with child porn, probably because they looked at his phone. And the murder investigation happens all the time. Yes, but not living with her, but was engaged to her. They did not live together, though.
Yeah, they were both in the child pornography. Like they were both there. The claim is that they're both the victim and him were taking part in this.
Allegedly.
Yeah. So living separate, and we're kind of unclear whether some or all of the devices came from his house or this house.
Yeah, we haven't been told where any of it was actually taken at. I mean, not that I'm aware of, but we haven't finished reading all the docs yet. So I'm going to finish this up so we can get to another doc. I know we have about half hour, 45 minutes left. So
See, Travis said. I mean, I think it is too.
the state does want it both ways, for sure.
Yeah.
But Your Honor, there's no conflict here because by saying what he's charged with, that's a matter of public record. By talking about what the possible penalties are, in doing that, he in no way, that's not inculpatory. He says, I know I've been charged with this. I mean, it's like when he's arraigned and they ask him, do you know the nature of your charges and the possible penalties? He says, yes, that's not incriminating. So I would argue there's no conflict here between the Fifth and Sixth Amendment as it relates to Trump's right confrontation clause. If there's a conflict, but if he's asked what he charged with and what are the penalties, I just don't see how he can take the Fifth to that.
And we're not getting into where at this point, as we discussed in chambers, at this point, we're not getting into where this sexual exploitation of a minor came from. We're not be talking about it coming off of his phone or who the victim is or anything like that. Just that he has those pending charges. And as far as
See?
pending from 10 years earlier, there'd be no connection at this point between him and Parcell. It just goes to bias. So there's no reason for him to.
But there's no question. It's my understanding, y'all correct me on this if I'm wrong. Okay, 9/11 will corroborate that he was the one there, correct? The 9/11 call.
If they, I don't know if they plan to play that or not, but
Yes, we do. Okay. So to that point, I mean, attacking him on bias when he's telling something that's clearly a fact that even y'all would probably agree to. And then I guess the other things that they plan on getting in with him.
there's multiple things. They're going into these mailings that were sent, having to do the harassment charge. They've already called Bradley Post a victim. So if he's a victim of these mailings, then this gets into implications of our client. So and once again, there's no distinction in any of the cases about what the witness is testifying about, like how damaging it is to our client. It's just the fact that he is testifying and he has these pending charges.
All right. Anything else?
Not this time around.
This is going to end.
Okay.
I'll be very brief. I'll just note that where Mr. Mormon is claiming that there's no differentiation, I suppose that ignores the factual analysis that the court goes through on each individual case in describing the pretense to the witness testifying, where the court always makes light of the importance of the witness's testimony, and that's noted in Delaware versus Van Arsall when they are reviewing this for harmless error analysis. And the importance of that particular witness's testimony is, I believe, the first factor that they analyze. And the hypothetical that the state put in its brief, or not the hypothetical, but the reality of when we're talking about what is the impact or the bias value of asking that question from the defense's perspective, given what Mr. Post is testifying to. So you elicit the question, aren't you charged with criminal sexual exploitation of a minor? Does that make the fact that he found her body that morning less likely? Does it make the fact that he received envelopes less likely? Does it make the fact that they were in a relationship less likely? Or what doubt does that cast on those bare factual bases that he's going to provide? That is the distinction when the courts are analyzing this as to the importance of the witness's testimony to the state's case. He is not sitting there saying Zachary Hughes sent those envelopes. Zachary Hughes committed this murder. Then, of course, where you would get into that same line of cross-examination, of course, that would project bias on the weight of his accusation towards the defendant. But we don't have that here. So that distinction is critical for the court to take note of, and that's why it is within the trial court's discretion to tailor the scope of cross-examination on a case-by-case basis, depending on what that witness is going to testify to.
And just very briefly, what Mr. Hopers was talking about right there, it goes into the analysis of whether it's harmless error or not whether it's error. So it is clearly error not to allow these questions to be asked of the witness. And courts are not supposed to analyze and try to drill down on what exactly the import of this particular evidence is. I mean, otherwise, we would have every witness who's testifying for the state who happens to have pending charges. We'd have to have in-camera hearings. How important is this evidence? Is it going to, how damaging is it to the defendant's case? We don't do those analysis. It comes down to a bright line test. Again, is it the state's witness, and does that person have pending charges? And
I'm going to take a little while. I'll get y'all ruling this afternoon. Hopefully, I was not taking too long. I mean, y'all have done just an excellent job on the briefing. So, to a certain degree, I've had a heads up on what I need to report. So, okay. We will take a break. Can't tell you how long. Hopefully, it won't be more than 15, 25 minutes, and then we'll be back.
And Travis, they did say that they didn't want it because it would be prejudicial to them if the jury knew that if the jury knew that the victim was involved in anything like that.
Hold on, I'm going to take it to the beginning of the first day because I think that's when they actually talk about it. Is this day one?
Oh, sorry. I probably shouldn't talk on this case because he's so low, and I understand people are struggling to hear him, and then I come in loud as shit. Sorry.
It's just yeah, because I bump up my speaker, and so then it makes you really loud, and it's controlling you compared to me.
At things and again,
You know what I mean? It's just tough.
The issues that are questions that I keep getting is, can we report contemporaneously, or does the 30-minute delay that is in my order, does that pertain to that? And I thought about it, and I will allow you to report. I don't think I can prevent you from reporting on that. Everything else in the order does stand. I don't think I specifically really addressed that point, but I just wanted to clarify that because I think there's been a lot of questions about that. I am concerned, though. I do not want people coming in and out of flurry. I don't do distractions. Okay. I think that will be the last time that we address anything to the meeting. But again, I'm thankful that you're here, and of course, we're open to the meeting. All right. I've spent a considerable amount of time looking at case law, these excellent briefs that have been presented to me, your oral arguments, and I'm going to grant the state's motion, amended motion in limine, and I'm going to exclude any reference to child pornography involving the victim, her juvenile daughter, I think it's A&P, or Bradley Post. So I'm going to be excluding that, and that also includes the cross-examination of Mr. Post. I will get into that in a moment. I know that we talked with counsel as far as your ability to do a proper, and he's going to be coming in for a in-camera hearing shortly. I find that it is not relevant under Rule 401 or 2. This evidence has no tendency to make the existence of any fact that is a consequence of this murder more or less likely. It will not assist the jury at arriving at the truth of this murder. The question is, did the defendant commit this murder? And that's the only issue. The child pornography is not relevant, and even if so, I would exclude it under Rule 403 because the probative value is significantly outweighed by, and I know normally we jump to unfair prejudice, and that is part of it, but I would focus on confusion of the issues and misleading the jury. If at some point it does become relevant, then that certainly could be revisited. And again, even if it were found to be relevant, which I don't think it is, it's not come in pertaining to Post under 608C for bias. I know that that was your argument. Certainly you're going to be protected in proffering, but Mr. Post, he's going to stand, or he's going to have his day in court, and he's going to have to, but he is not, he's not pled, and he's not been tried yet. He's not a co-defendant. He's not an eyewitness to the actual crime. He basically found the body of his girlfriend, fiance, and he's going to be here testifying under subpoena. And it's my understanding he's testifying to finding the body, reporting the murder, which is corroborated by the 911 phone call. And the investigator, the victim was his girlfriend, and he is a victim of harassment. He does have serious charges against him, but these are pending again, and he's innocent until he's proven guilty, and he will have a trial. Also, the Attorney General's office will handle this trial, not the Criminal Solicitor's office. He's not a cooperating witness. He's not providing any type of inculpatory, I guess, evidence linking the defendant to the crime. So they're not offering him in any way to like I said, to inculpate the defendant of any type of wrongdoing or indication of guilt. Also looked at the State v. Smith, State v. Mitchell, State v. I can't pronounce this, Beesry, or whatever, Pradubsri, and I don't find that the bias issues that were in those cases are in play here. I also reviewed, I think it's Delaware versus something. I think it's Van something, but thank you. Defense can ask Mr. Post if he has any pending charges, but not go into the specific charges. Certainly on proffer, there will be certain allowance, but I do have the right to impose a limit on the scope of defense counsel's cross-examination and not violate the confrontation clause. And that would be under the another wonderful art pronunciation of the Freidich, F-R-E-I-T-E-K-H case. Also, it would be consistent with Rule 611A. Okay. And I don't think I have anything else to add to that. Anything to say?
Nothing to say, Your Honor. So your wish now is to allow Brad Post to offer his testimony. For the record, Your Honor, what is the purpose of his proffering? So to allow the defense a cross-examination?
Yeah, and you're going
you just made.
You're going to ask the questions that you're going to ask. Even though I know that you've indicated that you did not feel that was necessary, but I think that allows them to have cross-examination on that. Counsel for Mr. Post will be here. I will have to, I guess, rule if he does assert the Fifth Amendment, then I'll have to rule at that time under whether or not it's just facially prejudicial to him, or somehow in a chain of events it could, be something improper to be used. Okay, but they still have the right in proffer to ask it to protect the record. Limited.
And that's in conjunction with your ruling, Your Honor. Their cross-examination under this proffer still needs to be in conjunction with your ruling.
Well, the proffer, I'm going to allow them to at least ask what he has been arrested for, but that will not be asked to the jury. They can't ask him, obviously, that he's here under arrest. When they do the in-camera, or when we do the in-camera, I'm going to have counsel for Mr. Post. I'm just going to ask them to sit over here. Mr. Marchand, you're here. Okay. Do you you got your other cohorts? Ready to go. Okay. Anybody else coming? Okay. All right. Well, I guess we just need to wait until he's here. Anything else, solicitor?
No, thank you, Your Honor, for that clarification.
Anything from defense? Did y'all?
Not right now, Your Honor.
Okay.
I think Mr. Marchand said we can proceed without Mr. Ariel, if that's okay with Your Honor.
No, that's perfectly fine. I just wanted to
We have the timeline of the jury be here at 10. If we can get through this, hopefully start this trial.
That'd be nice.
Bring up
Yes, sir.
So we don't get to hear the proffer?
Please place your left hand on the Bible. Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good morning again. There's no jury here.
We do get to hear it, but we don't get to see it.
To present your testimony so the judge can hear it, and the defense counsels will have an opportunity to cross-examine you.
I don't think we get to hear it.
Rude.
We know that he takes the stand. I think he's the second witness, first day. Yeah, they don't let us hear it. Okay, take that off. Go back to the documents. What were the documents that you sent? Do you want me to go through those instead of these?
I don't know. I don't know if you saw them. I was basically.
Gigi covered the proffer if anybody wants to watch it because she was in court. So pretty lies and alibis. Turn the volume down. There we go. Let me pull these up real quick. I don't think I pulled these up. This one is a motion for ex parte submission and ex parte hearing pursuant to. So this is prior. Okay, let me see. On at least 5 separate occasions over 3 years, both in writing and orally, Mr. Hughes has requested access to the contents of 8 devices owned by Bradley Post and seized by the Greenville County Sheriff's Office in October. On August 27th, for the first time, the state finally indicated that it would not produce these contents or provide the defense with access to these devices, despite having said only minutes earlier that it would provide access, even though it already produced the contents of one of Post's devices, which contained child pornography. The state now refuses to produce the contents of the remaining Post devices, in part because the device contains child pornography. The state's hopelessly inconsistent positions now require Mr. Hughes, unfortunately, to seek an order from the court compelling the state to either produce the contents of Post devices or to provide access to them. Then they go over the law, and they want him to be permitted to actually have that material. I just don't. Why does the defense need access to child pornography in the Post case? Why would that?
So I personally am uncomfortable with them having. Well, I should say I'm uncomfortable with him having any access to it. But if their intention was to, like I said, use Post as a third party person, then they would need to know what all evidence they could, or they would want to know what all evidence they could use against him for that.
But why would this be part of discovery in the murder trial? I guess this is where I'm trying to go.
Because the victim's in it too, I guess. It's part of a search warrant, I guess.
I'm surprised that the defense doesn't argue more about the fact that she's in the videos
Yeah.
versus post taking these videos. You know what I mean? Because I can see when they go with it just being about post, I don't think that's where my struggle is.
Well, it could also be that they're trying to confirm, like, some of the things, like how you were saying, like maybe they were trying to confirm that she was in them, or like whatever it is that they were trying to confirm.
That would be the only ones that would be relevant.
Maybe.
Well,
But it doesn't
unless
seem like they
you
were
go
giving
with,
them that either.
well, I don't think third party could really apply if they literally have this third party perpetrator somewhere else. Susanna, in one of the filings, they say, or maybe in two of the filings, I think it's in both the civil ones, they say that that she's in them. But we don't, is there proof of that? No, and we're not going to watch those videos. So I don't know. I mean, if they had proof of that. But is
Well,
that why,
also, would they
is that what
lie?
they're saying, is the state isn't going to turn this over because they don't want them to have proof that she's actually in them?
I mean, they straight up said that it would be prejudicial to the victim. So yes, I do think that they wouldn't want to turn it over if she was in them. They don't want the jury to know about that. That's why they went on and on about, like, not being able to unring the bell, even if they mention the fact that there was child or CSAM and that she was in it.
Okay, catastrophe. I can see where you're going with that. And it's like the KK drive, which they didn't actually get the KK drive. They were told if they wanted to look at it, they had to come to the department. They had to come to the DA's office to actually see it.
Oh, I have a perfect example. I'm glad she said that.
Yeah, that's a good one.
Let me ask you how you feel about this. So let's say that Richard Allen is going to trial and his attorneys are, let's say, allowed to do third party, or they were trying to go for third party and they were going for Keegan.
Yeah.
And part of that was the Dropbox. Well, let's say that, again, all of this is just hypothetical. Let's say that some of the folks who were in photos in the Dropbox or had access to the Dropbox before, like, police, found the Dropbox, and the state was going to call those people as witnesses. Do you think, even though Richard Allen knew nothing about the Dropbox at the time of the murders, do you think the defense should be able to bring that up about witnesses for the state?
Well, I think that you're running into a couple different things, because you have Keegan Kline, who's already convicted at the time of Richard Allen's trial.
Well, say it wasn't Keegan. Say, like, what I'm saying is say it is Keegan was who they were going to blame, because they can blame him whether they can blame Post whether he's been convicted or not. We know
Correct.
this.
Right.
So,
well, he says there's no nexus because they can prove that he's actually somewhere else.
well, we're not arguing the nexus thing. I'm tired of it. So let's say Keegan was supposed to meet up with them, and they had evidence of that he was supposed to meet up with the girls that day.
Right.
Hell, even Holman, who thinks Richard Allen is the only one that did this, still thinks that they might have went out there to go meet Anthony Schatz. So let's say that the defense caught wind of the state wanting to call witnesses to testify against Richard Allen, and they have knowledge that these people were in this Dropbox, and should they not be allowed to use the Dropbox evidence to impeach them?
Are you talking about, so if it was somebody else that had access to the Dropbox?
Yeah, like, let's say,
and you're talking like the third party, the people that Post would have sent the images to.
Well, no,
Yes,
because
it
they were
does.
Keegan's
That's-
I mean, if it was Keegan's Dropbox, then all of the images in the Dropbox theoretically belong to him, whether he took them or gathered them or whatever. Like if they're in his Dropbox owned by him, they're his. So if Post's devices that are owned by him have this stuff on it, let's just say that it's his stuff. They all belong to him. They're his. They belong to him.
Okay, so here, it goes back to my very beginning issue of the CSAM in this case. All the CSAM for Keegan Klein is found, and he's convicted, right?
Well, he
And
pled guilty. Yeah.
well, either way, so he's guilty of the crimes. You have here.
So what if it happened before he pled guilty?
I think that they would have the same issue as they're having here.
So, in theory, then what stops the state, just any state, from putting off a defendant's trial until they testify for the state in a different trial?
Wait, say that again?
Like, if it automatically makes all that stuff off limits, as long as the person that we're referring to hasn't been convicted. So Bradley Post or for example, Keegan Klein. Let's say if this happened before he was convicted.
Okay.
If it's just going to be automatically off limits because they haven't been convicted, then what's stopping the state from putting off that trial until after they get that person to testify for them?
Well, I think that's what we're implying that South Carolina has done for Post, is that they purposely have pushed his trial out so that they could have this trial first.
So does there not need to be some type of like remedy for that? Because like it feels like it's purposely withholding things that are like bad for your case as a prosecutor.
I guess I would be more curious if they give up the one hard drive, right? Is that the hard drive that includes her? And that
Was it a
makes
hard drive or device?
Oh, I don't know what they said. I don't remember now. I'd have to go back.
Because it could have been like a device with 5 things on it. It could have been like I don't think they were very specific. What's the point of turning over one device and then being like, nope, you don't need the rest of them? Well, I guess what they're implying is that the device they did turn over did not have any of that stuff on it.
Well, but okay, so we know at some point they end up getting whatever it is that they believe has her on it because they put it in motions, number one. And number two, during that pretrial hearing, they're talking about the fact that they could prove it. They would show the videos to prove it.
So then I'm confused why we are still like debating whether or not she was actually in the videos.
Only because nobody's convicted of anything. That's why we're not really debating it, I don't think. I think we're just continuously saying alleged because nothing's been proven.
But she's dead. So in theory, that'll never be proven. There could be images and videos of her in that stuff, but because she can never be put on trial, it will never be proven.
I don't think so, because we have the 2 civil cases that are claiming her as a defendant.
True. I do wonder how much of that they can show. Like, the sister is but that's also civil.
Right. No, she'll never be tried. No, I understand that, but I'm just saying, like, there is the fact that he's going to be tried for his parts in it, and if they're both in the videos, then I think it's going to be known that she's in the videos, number one, and then number two, there's at least two that we know of civil cases that are claiming she's part of it and suing her estate. Yeah, of course it's different.
So if you're talking about the potential for whether or how relevant the CSAM stuff is, just in general, if as a defendant your argument was going to be, let's get off a post, right? Let's instead switch to any of the people that they are exchanging CSAM with, or
Right. Well, that's where I was
that
going with
she,
it.
yeah, or that she was a prostitute. What about the people she dealt with there? In terms of, you know, who could have showed up at her house? How relevant is her victimology to the possibility of someone having, we don't even know, like, we don't know any other than the harassment, which I obviously think is proven. Like, we don't know if she was getting other types of threats, if people were responding to those ads
Right.
and contacting her. Like, we don't know any of that stuff.
Right. We don't. And I
So
think that actually could be a very big deal too, is what was happening with the rest of those ads. So two things real quick. Miku, we're not trusting what the government says. That's actually what the defense says and the civil attorneys have said. So the prosecutor or the solicitor in this case is not the one saying it. So they're saying that Brad Post and Christina Parcell are in these photographs, videos.
and that they'll show that they could show the videos.
That's what he said during that we have, like, we'll bring the proof of it.
But I'm of the opinion that, well, basically, like, unless you're Nick McClellan, because he's the only person that I've seen actually do this. But I'm like of the opinion that if an attorney, any attorney, is saying that they are going to show, you know, evidence, whatever, videos, or submitting this pieces of evidence as exhibits, you know, but they're under seal or whatever, I believe that what they're saying that exhibit is real. Or what they're saying, what the evidence, because, like, imagine you're like, we have video evidence and the victim is in the videos, and then, like, the judge watches it and she's nowhere to be found.
I think that's the tough part, is because none of this is resolved. We don't know. We can only go off of what all the filings and stuff are.
I still think they should have been allowed to bring in post CSAM stuff, in terms of, because he does have pending charges. It does go, in my opinion, to whether he's a biased witness or not. And
even if he's not being tried by the same office.
Well, the state is the state.
True.
He's being tried by the state. He whether it's a real, you know, whether he was actually really offered anything in exchange for his testimony doesn't mean anything if he thinks in his head that he might have some leniency for saying what he's going to. See, and then the judge's argument is, well, all he's testifying to is basically that he walked in, he found her, he called 911, and those are not facts that are in dispute.
Right. That's all he's allowed to say.
And they let the defense ask if he had pending charges, just not what they were, which, again, like, I just feel like, so what's the purpose of allowing them to ask if he has pending charges? It's to see if he could be biased, or if he's trustworthy or whatever, like, so that they can determine how to take his testimony, like if he's legit or not. So I'm going to take what you say a little differently if I find out that, like, you have pending charges on a DUI versus you have pending charges, you're in prison or you're in jail right now on pending charges for CSAM. That's different. You know?
I agree.
I mean, I'm more willing to believe you if you're there for a DUI than that, you know?
Yeah, because you're obviously just a shit person. So
yeah.
So Law Junkie, according to the civil suit, that her parents don't actually find out about it until they're approached from the investigation. The way I read that suit earlier in the live, they don't know about it. They only find out about it after, which is my whole thing. Like, how do you go third party and say that somebody else that's involved in the CSAM if you don't actually have anybody else who knows about the CSAM? That was my whole thing.
Yes, Travis Post testified and he is in jail.
Yes.
Well, and so is Zachary Hughes, so.
Yes. Okay, so that evidence can be locked down in the civil case if she was soliciting in person or video streaming, then it's relevant. Okay, so the accusation is that in the videos / photographs that are taken of the children, that she can be seen in them. One document alleges that she's seen like positioning the girls, or at least one of the girls, in a sexually explicit way. Streaming, no, but they are accusing both Post and Parcell of distribution after the fact. So I don't know if that changes anything of your comment.
It says plaintiff is informed and believes that the defendants knowingly and intentionally forwarded sexually exploitative exploitative
Exploitive.
there's two eyes.
Exploit, and then iv.
Oh, exploitive.
Yeah, there you go.
Photographs and videos of Jane Doe to third parties to be viewed and further disseminated for viewing by others.
Yeah. Well, I think this is why this is like the biggest point of contention in this whole trial was, should this have come in or should it have stayed out?
There was other.
Who's he? Does he have a civil defense attorney? Brad Post? Yes.
Yes, definitely. And then it's him, and then it's the estate of Christina Parcell, which is her sister.
Lutina.
The ads are basically like prostitution, like website ads with photographs of Christina.
Yeah. They're escort ads that they use the old photographs of Christina nude went from when she was with Melo. So they took old pictures and created ads to say that she was an escort, and then they turned those ads over to the attorneys saying, hey, look at, she's out here prostituting, and this is why she shouldn't have custody.
And that's my point. Didn't it have like a phone number on it and stuff like that?
It had that message thing, didn't it? It had a messenger.
I mean, I cannot imagine that they would not put actual phone number if the whole point of doing so was to get them to think that these were legitimate ads.
Yeah, because they read the messages that was supposedly coming in and out.
Yes. So again, I just, even if that wasn't Christina and it was them, I still think that's relevant because and the defense really should have argued that, because who knows who contacted her, who could have become obsessed with her, and they seen these ads if they actually went live. I don't know if they ever went live versus just, it almost seemed like they were saying that they were only printed out. And that's why, because did you notice they'd say stuff like the margins or like the orientation were different on each one?
No, I missed that.
Yeah, he was saying something about like the margins of it being off, like for every single one, that it was different from the one previous.
Oh yeah, I didn't know that.
And I didn't get why, but I guess I'm thinking if they weren't all like, I go on a website, I see this ad, and so I make 500 copies of it while I'm sitting here in front of it, it should all look the same. But if I'm creating these over and over again with different pictures and things like that, then they won't print the same. So I don't know if it was ever live or not. The defense did hint towards that, meaning that cop was like, I wasn't able to find it, the website. And the defense was like, okay, but you couldn't find it when you looked, but that doesn't mean it didn't ever exist.
They were trying to say that she, back in the day, when her and Melo started dating, that she was an escort.
But we do have evidence she was at some point, right? That's what this other guy showed up.
Not put into trial, no, but it's been said that she was an escort at one point. He was married when he started dating her.
Are we talking about the Alex guy?
Oh, you know what, Aaron? I wanted to ask you about that. Wait a minute. So can you explain? Because I thought you had told me that Alex Fields had to do with Melo. So now I'm thinking that I misunderstood what you had said, because you mentioned in chat now that it had something to do with Christina. Can you tell me, how do we find out more about this Alex Fields proffer? Like, where's that at?
And it definitely is the guy that I saw, the young guy.
Yeah, according to Aaron, yeah. The one that was killed in a motorcycle accident.
Yeah.
So this was, I guess I should have already read this one. This was the defense's response to the state's motion in limine.
So this
says,
should explain what they exactly wanted.
At 11:08 a.m. on October 13th, a deputy with the Greenville County Sheriff's Office arrived at the home. After Bradley Post called 911 for help, a deputy arrived and saw Post outside the home talking on his cell phone. The deputy approached Post to determine what was happening. When the deputy began to ask Post questions, Post instructed the deputy to wait as he continued to talk on his cell phone. According to the deputy, Post was shaking a little bit but did not appear to be too upset. Post hung up the phone and told the deputy he decided to come to the residence after he attempted to call his fiancée, Christina Parcell, and she did not answer. According to Post, he entered the residence through the back door, as they always leave it unlocked, and he found Parcell lifeless on the floor in the front living room. Police did a sweep of the residence and found no one else inside. The deputy who responded walked outside the residence and reestablished contact with Post for the purpose of continuing the investigation. During the deputy's interview, Post became nervous and asked if he needed to speak with his lawyer. Despite the fact that the deputy was just asking basic questions about the incident at the time, Post asked for a lawyer. Post then provided the deputy with the name of the person whom he believed killed his fiancée, a name that was not Zachary Hughes.
Yeah, and I forgot about this. I don't know if it's in this one, and I don't know that it came up in his cross-examination either, but at some point they were mentioning how suspicious he was because they like had him walk through the crime scene with them and he had gloves on.
Who did? Post?
Post. That he like walked through the crime scene with them. Now I have to find that in case it's not in here, but you carry on if you come across it.
Okay.
But I know I saw that.
The police's investigation quickly uncovered why, in part, Post was acting nervously when the deputy responded. At the time of Parcell's death, Post and Parcell, working together, were producing and or distributing child pornography involving multiple minor children. Post is currently incarcerated in the Greenville County Detention Center awaiting trial. Portions of the quotes come directly from police reports. Deputies also interviewed Post a few days after the incident. In this interview, Post refused to answer multiple questions and refused to provide the PIN number for Parcell's phone until he could get advice from a lawyer. Okay, so 7 counts of sexual exploitation of a minor, 1 count of criminal sexual conduct with a minor, and 1 count of buggery. So that's the 9 charges. Despite Post and Parcell's prolonged, calculated, and disgusting conspiracy to victimize and sexually abuse young children, the state has indicated as recently as December 4th, 2024, that Post is a material fact witness and is a potential prosecution witness. On at least 5 separate occasions over 3 years, both in writing and orally, the defense counsel requested access to the content of 8 devices owned by Bradley Post. This is a copy and paste from that other document. Although it's already produced the contents of one of Post's cell phones in 2021, which contained child pornography, the state refused defense counsel's access to any of the contents of the remaining devices until September of 2024. Remarkably, the state also publicly filed its initial motion in limine on September 12, 2024, which sought to exclude the child pornography evidence from Post devices in the trial before it even provided defense counsel access to this material. The state has so vehemently wished to excise this evidence from the case that it did not want Mr. Hughes to be able to respond to the motion. How could he respond when he had not even seen the evidence that was the subject of the motion? Since filing the motion in limine, the state has begrudgingly granted defense counsel access to the child pornography evidence. Defense counsel has met with personnel from the GCSO to review the contents of these devices, and Mr. Hughes has retained an expert who has forensically analyzed the contents of these devices. This review has caused defense counsel to conclude that the contents of these devices are even more material to the preparation of Mr. Hughes's defense than they initially believed. So Christina Parcell and Brad Post work together to victimize young children whether the state likes it or not. In the more than 3 years it has prosecuted this case, the state's attempt to purge the case of this fact has caused it to pursue courses of action that are internally inconsistent and contrary to state and federal law. In addition to initially providing contents of one of Post's devices in discovery and then denying access to the rest, and in addition to filing a motion in limine publicly and then filing an amended motion in limine on the same issue under seal, the state now invites this court to speculate on what may or may not happen at a trial at least 3 weeks away, and a rule that all the child pornography evidence is inadmissible. This court must reject the invitation. Mr. Hughes will address the misplaced arguments the state makes in support of its motions, but first he wishes to correct misstatements the state has made both in its written motions and orally before the court. Defense counsel stands by comments they made in Mr. Hughes' motion for bond. We did not actually read through that one. I think that one's pretty long. I don't know. I didn't read through that one, I don't think. In a companion motion to its motion in limine, the state's motion for a gag order, the state references language contained in Mr. Hughes' motion for bond, which was filed on October 30th, 2024, and accuses defense counsel of making irresponsible and baseless allegations. Defense counsel brazenly alleges that the victim of this murder, Parcell, produced, directed, and participated in child pornography. Not only is this allegation inadmissible, it cannot be proven by the defendant and is wholly unsubstantiated.
Which obviously they can't prove it if you're not giving them that discovery.
Right?
So.
Okay, so further, the state's motion claims that should defense counsel continue to litigate discovery issues related to the child's pornography, they would be releasing unfounded, salacious, and ultimately criminal accusations toward the victim. Well, okay, so they're saying they're unfounded, salacious, and criminal accusations towards the victim. Like, so they're unfounded? Now they're saying that she's not in there? Also, in its motion for, go ahead.
Well, I'm just thinking, like, they're saying these things while then refusing to turn it all over. And it's possible that they were talking to the civil attorneys. But they obviously have it now if they said that they would produce video and photographs with her in it.
Okay, so also in its motion for gag order, the state refers to language in Mr. Hughes' motion for bond that Parcell produced, directed, and participated in child pornography as conclusory allegations, wholly unsubstantiated, unfounded accusations, and unfounded allegations no less than 7 times. In its amended motion in limine, which the state improperly filed under seal on November 6, 2024, it continues to claim that the defense counsel would be irresponsible if they were to allege publicly that Parcell and Post committed a crime. Defense counsel would be releasing unfounded, salacious, and ultimately criminal accusations toward Parcell.
They could be saying that too because she's not been charged or found guilty, which obviously she can't.
But they're not. But they're allegations, and they're calling them unfounded, like she's not in these videos.
Well, I mean, it's not true.
Yeah, they filed their amended motion in limine. The original one was filed publicly. The amended motion was filed under seal. That's interesting too. But I mean, okay, the state has serious concerns about defense counsel saying things that are not true or alleged or unsubstantiated about Parcell in public filings.
Oh, say, keep going.
On September 25th, 2024, defense counsel met with members of the GCSO for the purpose of reviewing the contents of Post devices, to which the state had denied Mr. Hughes access for more than 3 years. During the review, the defense counsel viewed the contents of a thumb drive law enforcement seized from Post labeled SEM1A. The GCSO deputy opened a video file named, 415 move, but which was contained on the SEM1A. The video begins, the video begins with a minor child on a bed in the nude. Parcell emerges from behind the camera, nude, and climbs on the bed with the minor.
See?
Both then engage in, Both then engage in sexually explicit and coordinated poses.
This video appeared on a device not capable of capturing the image and is in custody of another person, Brad Post. I
Wait,
wonder if it
the
was
video
like
appeared on a device not capable of capturing the image.
maybe like like a webcam.
Oh shit.
Yeah.
And it appears on his phone or his computer.
Well, if he was like if he was like recording them that way, or even like a nanny cam,
Yeah.
that's fucked. See?
Mav's like, see, I've been telling you this, Teresa. Skinny's like, don't read all this. Okay, hold on. Okay. So the video appeared on the device not capable. Okay. Under these circumstances, Parcell not only produced, directed, and participated in child pornography, she also distributed it.
See, and so she must have sent it to him, or he, but see, that's bullshit, because like you just said, they went on and on with the unfounded stuff, and clearly they would have known that she was in those videos.
It's on a storage device. That the storage, like if it is like on a hard drive or or on a thumb drive, it can't capture anything, so it had to be moved there.
That is
okay.
fucked.
So defining producing in the child pornography context as producing, directing, manufacturing, issuing, publishing, or advertising. The depiction include any photograph, film, video. Okay, so that's just the legal side of it. Okay, so if the state had taken the time to carefully review the contents of post devices, it would have seen this video and likely many other files that contain similar images, and realized defense counsel's claims were well-grounded, supported in fact, and simply the truth. In determining how much weight to assign to the state's arguments in these motions, the court should be mindful that the state apparently seeks to limit discussion of and introduction of evidence it has not even reviewed.
Yeah.
Generally, a motion in limine seeks a pretrial evidentiary ruling to prevent the disclosure of potentially prejudicial matter to the jury. A pretrial ruling on the admissibility of evidence is preliminary and is subject to change based on the developments at trial. Okay, so here's more law. I want to go back into in its 27 pages of pleadings, both in its initial publicly filed motion and then in its secret hidden motion, the state refers to the evidence it seeks to exclude as child pornography. It provides no other description of the contents of post devices, not even any generic sanitized characterizations of what these images and videos contain. The state's attempt to exclude an enormous universe of evidence, more than 15,000 images and videos of child pornography contained on 9 electronic storage devices, instead of a few carefully selected and precisely described pieces of evidence, also should prompt this court to defer ruling on those motions until trial. More law. The state's failure to describe with any specificity what it seeks to exclude also reinforces the conclusion that it may not have reviewed the contents of post devices. Are there images and or videos on these devices that arguably could be or could not be considered child pornography? Does the state seek to exclude these items that would be close calls? Does it even know if it exists? The state claims that defense counsel's descriptions of the contents of post devices are wholly unsubstantiated, even though the contents plainly support the descriptions. Couple this fact with the state's apparent inability to describe any images, even in a non-offensive, sanitary fashion, genuinely calls into question whether the state really knows what evidence it seeks to exclude. In its motions in limine, the state desperately attempts to eliminate all potential grounds for admissibility of this evidence by guessing as to how Mr. Hughes would seek to introduce this evidence and by hastily constructing false assumptions that are necessary to support its arguments. For example, the state claims that using the child pornography evidence to impeach Post would be improper. In a strained and incoherent attempt to bolster this notion, the state writes Post faces charges of that are being prosecuted by Attorney General. Accordingly, he has been offered no deal in exchange for his testimony. What does this mean? Does it mean that the Attorney General never makes deals? Defense counsel can attest that that is not true. Does it mean that the Attorney General has not made Post a deal in his case in exchange for his testimony? Does it mean that somehow because the Attorney General is prosecuting Post instead of the 13th Circuit Solicitor's Office that Mr. Hughes cannot cross-examine Post on bias he has or reasons he would have to lie? Surely this is not the import of the state's argument because it would render the state's argument absurd. Both the 13th Circuit Solicitor's Office and the Attorney General represent the same party, the state. Multiple scenarios likely would occur at trial that would render the child pornography evidence admissible, both in the context of post-cross-examination and in others. Let me see if there's anything else in here. The subject of the jury testify likely along with the horrible images Post and Parcell produced, participated, and or distributed that support these charges. I don't see... Brad Post is an important character in this case. He's the one who found Christina Parcell. He was the deceased fiancés at the time. If and when Post testifies about his relationship with Parcell, the testimony will expand the scope of relevance to include the nature of his relationship with Parcell. If Post testifies on direct examination as to the full nature of his relationship with Parcell, that they worked together to victimize young children in addition to being romantically involved, the state opens the door to more questioning and child pornography contained on Post devices. If Post neglects to discuss the aspect of his relationship with Parcell on direct examination, defense counsel will be able to undermine his credibility on cross-examination by presenting evidence on the full nature of his relationship with Parcell,
I'm sorry, I agree with all of that.
Would have deceitfully omitted during his direct examination. I don't disagree either. These two scenarios and many more illustrate that neither the state nor anyone else can show that this evidence would be inadmissible on all potential grounds. Therefore, the state's motion in limine should be denied at this time, more than 3 weeks before trial. I think I'm just struggling with about keeping her stuff out. But I also don't know how that would benefit the defense outside of just making her a victim that nobody gives a shit got murdered. But it doesn't prove that Zachary Hughes didn't do it.
Like I said, if they were mixed up in that kind of stuff, it then opens up to what other type of people would hurt her or want to hurt her.
Well, they
did
didn't
a
show,
victim's
nobody
family
has
find
stated
out?
that they actually gave it to another person or who the other people are that received it. Like, we don't know that. They're saying distribution because it's moved from one device to the other device that can't actually record it. That could be distributed. Are they actually claiming that they did give it to third-party people? Do you know what I mean? Did somebody else actually see it?
The civil case does say third parties. I think we can say now that, like, the civil case, the stuff that they put in there is true in the sense that the stuff related directly to the criminal stuff is true. I'm sure they saw it.
Well, I think the only reason I'm thinking that it matters, Miku, is because of the fact that they're trying to go third party. You have to have another party that knows that this even exists. And at that time, nobody else knows it exists. So, like, do you have to prove that somebody else would even know it exists and then be able to create the quote-unquote nexus to the crime scene? Do you see what I mean? Because none of this is found until after she's dead. So I'm just trying to think of how it would benefit his defense team.
Demand for this material. Yes, difficult to fathom, but then you have a book. Wait, what?
Wait, where are you at?
Reading Travis's. I must think
yes, difficult to fathom, but then you have a book, Lolita, mid-50s, the man's relationship with 12-year-old scandal at the time. Are
that's
best
what I got lost.
novels. Oh yeah, he's talking about the book Lolita. Didn't they make it a movie? I'm just thinking, I just don't know how it would benefit them unless they could prove that somebody else actually had access to it outside of them. And if you're going to go with third party being Brad Post.
Or maybe it was the Alex guy, and that's why he has brought him up several times.
So Alex Fields, so Aaron said that Alex Fields was solicited by Christina in the past for sex and drugs. I'm going to have to see if I can find that proffer. Aaron, if you're still in here, can you help me find where you're finding that info? I would love to see it, read it, know more about it. He was solicited by the victim in the past for drugs and as an escort. He was interviewed by police. He died last year in the motorcycle crash.
I mean, technically, anybody who was potentially receiving Oh, see, I don't think we read it either. But then you have like people whose animals went to the vet clinic. Like that's another accusation against the victim, is that like people's pets and shit like were showing up in these videos and pictures and whatnot.
Right. They didn't get too far into that part. All right, you guys, I'm going to wrap this up. Bob is live and Andy Baldwin is going to be on, and I definitely want to watch that. I also have to go cook dinner. This live is going to portal you over to Bob's live if you want to stick around for the end of this. If not, you guys know how to find Bob at Defense Diaries. But thank you guys for hanging out. We'll be back tomorrow to cover day five of the trial of South Carolina versus Zachary Hughes. And Aaron, I'll check that out. Thank you. So thank you guys for hanging out and going through all of this. I know this was a tough one. This was a lot of info. I can definitely see why there's such a divide amongst people on whether this should or should not have been in. I don't know if I have the answer for that for you. So, but once again, I know that you guys have 1,000 other places that you could hang out, and I appreciate that you choose to hang out here with us. So I will see you guys over at Bob's. Have a good one. Love you, Sleuthy.
Love you. Bye.
Love you. Bye.
Do you dare to fall